But may I mention, my lord, the matter, my lord, appeal from orders is appearing in your lordship list as item number 84, my lord. Here, what has happened, my lord? There has been I am for the respondents, the respondents are suffering an interim order, my lord. Of the pendency of the appeal, my lord, 3 execution applications have been stayed, my lord. The lordship will kindly fix up a date and time, my lord, as convenient to your lordship's name.
Sunday week, 10:30 usual, Sunday. Next,
Monday week.
Sunday week.
May I be Lord, upon notice, my lord, I mentioning. My lord, upon notice, my lord, I'm mentioning one matter, my lord. Appellate side commercial division, my lord, that Indian performing rights matter, my lord.
Yes, yes.
My lord, tomorrow your lordship has fixed the matter, my lord, for under the heading hearing. My lord, tomorrow, Mr. Bachawat is arguing for the appellant. My lord, we are for the respondent, my lord. We have some difficulty, my lord. Mr. Probal Kumar Mukherjee is appearing, my lord, tomorrow. My lord, he has some difficulty. If it can be posted any day in the next week,
Next week, your lordship,
কবে হবে তাহলে বলো?
উপরে
কালকে আসো।
কালকে আছে। এই যে নাম্বার দিন। Commercial division.
Next Tuesday?
Machi. Tuesday.
Hey.
Machi.
Lordship, this is coming at my instance. I am the applicant. Your Lordship would remember this was an application for discharge of the receiver of Special Officer Mr. Deepak Dev. Your Lordship had passed the order on 15th of May, appointing a new person. My lord, thereafter, that new person was not willing to act as a receiver, and we had mentioned the matter. My lord, your lordship will kindly, my lord, we have a name. Your lordship will kindly consider.
You're on the other side.
Your Lordship, I appear on behalf of the company which was in liquidation. So my instructions are now the company has been revived and the company is up and running. The creditors have been paid off. So I only seek time to come up with a appropriate application.
We had granted you 2 weeks time, Mr.
But your Lordship, since the cost papers are very old, my advocate on record could not have laid hands on the entire cost papers. So I was praying for a further period of 3 weeks, subject to what
No,
was
you
from your
can
Lordship.
pray for anything that your client has instructed you, but we are not willing to give you so much time. Ask your client to pull up its socks. We are granting you finally 2 weeks time. Do whatever you can.
Very well.
If not, we'll pass an order.
Very well, Lordship.
Because Mr. Dev must be discharged. He's not keeping well. He key next slip ta dilo.
My lord, Mr. Manish Roy, Parliament.
Anyway, we'll see. Come back after 2 weeks. Mr. Kothari, learned advocate appearing for the company which went into liquidation, says that the company has revived. Stop. He prays for 2 more weeks to file an appropriate application to bring on record relevant facts. Paragraph, we had granted Mr. Kothari's client 2 weeks on July 24, 2025. Stop. More than 2 weeks have elapsed. Stop. The company has done nothing. Stop. Paragraph, for the ends of justice, we adjourn this matter peremptorily for 2 weeks. Stop. The matter will be listed again on Kobe 27. Stop. If in the meantime any application is filed by any of the parties, comma, the same shall be listed on that date.
Not only thing I was saying, not the only prayer here was not to change the name of the receiver.
We
Not
remember.
what is happening, not the now the not the state note is in the limbo, not because not the previous receiver not has been discharged, and the new receiver doesn't want to act. So
No,
not for months to.
In view of what he says, if he's right, I'm sure he is. If the company has come out of liquidation, would the receiver continue?
Not he'll have to be not formally discharged. Not
That we will.
That order is
Finally 2 weeks. Let us see if he comes up with any application.
not because
Otherwise, we have a name.
yes, not anybody. Not, in fact, that is just not anybody. Not, we,
Right. Come on the 27th.
Because
Final, Mr. Kothari. We have
not
made it clear.
considering Mr. Dev's health, not we are very apprehensive, not because he has to hand over, he has to
understand.
take charge, not take the accounts, etc. Not that is what our
2 weeks. 2 weeks, it will be done.
May I beseech your lordship for one more indulgence? Since the official liquidator is also a party but is not appearing, if your lordship will call for a report from the official liquidator in the meantime, that would also,
Yes, why not?
because that will
Paragraph
clear out
on the next date, comma, the official liquidator attached to this court shall file a report as regards the status of the company in question, file a comprehensive report. Stop. Paragraph. Let this order be immediately communicated to the official liquidator's office by by the learned registrar. No, it is the original site. Learned registrar, comma, original site.
grateful lordship.
Yes,
Still not complete. I have not received the. I don't know about my. We have not received.
the decree has already been finalized and engrossed. It will be today sent to the collectorate for being assessed. The parties will pay whatever, I don't know what is to be paid. Keyboard, stamp duty. Stamp duty to the Kolkata collectorate, and you will get copies after that.
Can we get a chance to see the decree?
Nothing. You have got enough chance.
The final decree has not been circulated yet.
Final decree be given to
Draft decree was circulated.
draft decree was circulated.
Yes, fine. It's only that. Enough is enough.
After that, if there is some change, we can just have a look today and
No, no,
I understand, there is some objection.
nothing.
We had raised, but if
No,
the-
no objection from us.
No objection suggestions which we had raised.
28 years is far too long a time, Mr. Banerjee. Let the decree be drawn up and completed. Do whatever you like after that.
A chance, that is what.
We are only
let
to see
the
the
matter-
draft decree.
Learned master who is present in court tells us that the decree has already been finalized and engrossed. Stop. Engrossed. Stop. The decree will be sent in course of the day. Sent to the Kolkata collectorate by tomorrow for being assessed for stamp duty. Paragraph. Therefore, we see that the duty is almost the decree is almost is about to be completed. Almost is about to be completed. So, paragraph lists this matter. 2 weeks. Oh, it's up to them now.
My lord, we kindly keep it, my lord, after, my lord, 1 week, my lord. We will, my lord, submit within this week itself.
Let the assessment now has to be done. That is what lordship is following. It's a
One
question
second,
of payment
আজকে
of
হচ্ছে
stamp.
বুধবার। Monday weekটা করে দাও তারিখ। Next.
May I make one humble submission? May I make one humble submission? Can it be any day after the 1st of September? 25. Well, I have a leader who will not be there in town. That is my only.
What will happen on that day?
Well, at least we
will not hear you. If you have any objection to the final decree, you have to file appropriate proceedings, if that is permissible in law. On that day, nothing will happen. We'll just record that the decree has been made over to you.
Has kept it on 25th. I was humbly saying 1 more week. That would be kind.
Who is leading you? Doesn't matter, whoever it is. Where has he disappeared?
He has a fixed matter to him, sir, at 10:30. That's why he couldn't appear.
Where will he disappear? Why will he not be available till the 1st? Ladakh.
Decree, we'll see to the decree and we'll make me a submission. Let it be complete.
I do not know, whether he is in the correct matter, because all this year, 28 years, he has never
Let him appear if someone is
at the
appearing.
fag end of the matter, new counsel. And
I
I really
appear
don't
for
know
the
if the
respondent.
wakalatnama is also filed.
You are for Kushum Agarwal? Sorry, Kushum Agarwal. তাহলে ওটা করে দাও ডেটটা 4 August 4 করে দাও ও সরি দাঁড়াও তাহলে 1st September
After
2nd September. Great.
Please, Your Lordship. My Lords, I appear for the appellant petitioner in these matters. My Lord, on the last occasion, my Lord, I had moved the application. My Lord, my learned senior friend had said, my Lord, copy was not served. I have served afresh and come back. My Lord, affidavit of service is ready. My Lord, here, my Lord.
The key.
This was, my Lord, this appeal arose out of, my Lord, an order in a winding up proceeding, by which we were directed to secure the amount, subject to which, my Lord, the winding up would remain permanently stayed.
You are the company.
I'm the company. I came up in appeal. The appellate court, my Lord, modified the order by saying that you pay 3 lakhs to the petitioning creditor and the balance secured by way of bank guarantee. But I'm very grateful to my learned friend.
Oh, he has not filed any proceeding since then.
He has not filed, and also, my Lord, very fairly, he has just informed me, because there was no averment in the petition, and I have taken instructions. Since it relates to 2011-12, there is no document that the company can get hold of to show compliance with the monetary amount of 3 lakhs that was to be paid to the petitioning creditor. Bank guarantee we have furnished pursuant to the order that has been kept periodically renewed up till date. 2025, I think March was the last date of extension. Now, the application was for recovery of the bank guarantee for release. But as I had said, just now Mr. Singh has informed me that the 3 lakh payment they have received.
So your client has not filed any proceeding.
The order, Your Lordship will find the division bench's order is at page 52.
Which was the order from which you went up to the division bench?
That is at page 50.
Issue. You are Jupiter.
Yes.
The respondent herein filed an application for winding up of the appellant company being CP number 172 of 2011. Stop. An order was passed by a learned judge on February 7, 2012, the operative portion whereof reads as follows. Page 51 থেকে সেটা out করবে. Next. Page 51. Huh? The company went up on appeal. Stop. The appeal court passed an order dated February 23, 2012 in ACO number 38 of 2012, APOT number 95 of 2012, the operative portion whereof reads as follows. Page 52 or 53 থেকে সেটা out করবে। Paragraph. The appeal is still pending. Paragraph. Learned advocate for the appellant says that the amount of rupees 3 lakh was duly paid to the respondent herein. Stop. The balance amount was secured by way of a bank guarantee, which has been kept renewed till date. Stop. Where was any time period that was granted to your client for?
Yes, 6 weeks.
I see. Yes, yes. 7th February, the single judge. Stop. The respondent company has not filed any legal proceeding for recovery of its balance dues either within 6 weeks from February 7, 2012, which was the time period granted by the learned single judge, or at all. Stop. Hence, the bank guarantee that the appellant has furnished by way of security should stand discharged, released. Paragraph. Mr. Singh, learned counsel appearing for the respondent, in his usual fairness, says that the sum of rupees 3 lakh was indeed received by his client in terms of the order dated February 23, 2012, passed by a coordinate bench. Stop. He also says that his client has not filed any legal proceeding for recovery of the balance dues. Stop. Hence, he says that he should not be opposing the prayer made by the appellant. Paragraph. We appreciate the fair stand taken by Mr. Singh. Stop. Paragraph. In the facts and circumstances aforestated, there will be an order in terms of prayer A. Of the, you've taken out a notice of motion?
Yes.
Of the notice of motion. Paragraph, whatever application stands disposed of. What remains of the appeal? This application stands disposed of, number to the paragraph. Since no useful purpose will be served by keeping the appeal pending, as suggested by learned counsel for the parties, the appeal being such and such also stands disposed of.
Very good.
This is the application, my lord. Your lordship will recall, my lord, we had submitted that whatever amount has been attached by the executing court, we will deposit it as by way of a cash security with the registrar original side. That is what, my lord, your lordship asked me, Lord, Mr. Aniruddha Mitra, appearing at that point of time to take instruction. Well, appeal is against the decree for eviction and mean profit. There was a yes, and my lord, there was a
the decree in execution. You have put the decree in execution?
Yes, I did not satisfy.
I shall tell you, Lord.
The decree was passed, decree for eviction.
If I may just 1 minute and Mr. Mitra takes over. But a conditional order of stay, because I have a bad case. But I must tell your lordship, Lord. Was a conditional order of stay. I could not fulfill the condition of stay.
Stay of the decree passed by the
Appellate court.
appellate court.
Appeal court granted a condition for stay of the decree. That stay I could not.
Which is that order?
Yes, Lord. That order is at page 14. Kindly come to page 15, second paragraph. We accordingly direct appellant to deposit a sum of rupees 3.50 crores with the registered original side within 3 weeks from date to pay occupational charges at the rate of 3.50 lakhs on and from September 19 until disposal of the appeal. Deposit of the said sum and payment without prejudice. In default of compliance of either of the decree holder shall be entitled to put the decree into execution. Operation of the decree shall, however, remain stayed initially until 10th September. And in the event these are paid, it will continue. Registrar shall deposit. In addition, appellant shall pay cost as a condition precedent for condonation of delay. So this and the deficit court fee and 25,000 was put in. Appeal was regularized by putting the deficit court fee.
25 lakhs?
No, 25,000.
25,000.
Cost for condonation of delay.
Oh, I see.
And deficit court fees. So, my lord, the appeal was regularized, but condition was not fulfilled for stay. We had filed paper book also, my lord. Next order records that. My lord, in the meantime, my lord, we had surrendered possession to the decree holder. Now the appeal remained with regard to the decree for mean profit. Now, my lord, we came across this order of July 1, 2025, page 19, passed by the executing court. Execution case is filed in 2024. And, my lord, this order is communicated by my erstwhile advocate, whereby 5 crore 18 has been attached in my bank. Paragraph 7 at page 20.
Yes.
No, Lord, I had submitted on the last occasion before your lordship, my lord, that there has been substantial delay, my lord. I have made out some grounds for condonation of the delay because the appeal had stood restored in the meantime, had been dismissed for default. So this is an application for condonation of delay in filing the restoration.
Oh, in filing the restoration?
Yes, of the appeal.
It was dismissed for default?
Dismissed for default, my lord.
Yes.
Well, I am submitting this, my lord. The appeal will now remain, if it is restored, only for the mean profit. But I am putting in, my lord.
No, first let it be restored. There is no appeal today. They are going to oppose it.
Well, I had submitted on the last occasion. I will secure the entire amount.
Don't oppose, Mr. Mitra.
Entire amount which has been attached.
No. They are not doing charity to my client. I shall tell your lordship, my lord, the decree provided for
whatever the amount at the rate directed by the decree or the appeal court, that amount it will secure. So let us restore the appeal first. Then we are not passing any order after that. Let the appeal be restored.
So far as well as the rent is concerned, I am not going into
Tobey আমরা surrender করেছি পদেশে
rent along with the interest as granted.
এটা তত কি দেবো তারপরে দেবো
22 crores.
22 crore?
Yes. Rent with interest as decree.
We will.
I am not going into.
But where kindly see, my lord, the decree once and the condition of stay of the appellate.
Mr. Sen, we are dealing today with a restoration application.
Yes.
We are, if we restore your appeal today, we are not going to pass any further order today. If you can enter into a dialogue with Mr. Mitra, or I mean your client with Mr. Mitra's client, even at the execution stage, mediation is possible. If you like to go for mediation, we can organize that. We would strongly suggest you do. This is a 90-day mediation drive that we are following nationwide.
We can go for mediation, my lord. But kindly see, I have surrendered possession in 21.
That's all very well, but
So I will have to, even if the occupation charges is required to be paid up to that date.
I do not say that.
I cannot
I
go
say
come.
that, my lord, the rent along with interest. I am not going into the mean profit part for the time.
till the date of their vacating, till the date of vacating.
No, my lord, the tenancy was determined, my lord, rent till that date and thereafter, my lord, mean profit. I have, my lord, calculated it, the admitted portion. The rent as on the date of the filing of the suit or the notice, and my lord, interest thereon as not. If the mean profit portion is something there. This
The
22
execution
crores
is
does
reported
not
also?
include the mean profit.
You have preferred an appeal against the 1st July order? No.
No, from the decree. Appeal is from the decree.
Why don't you go before the executing court and say that we'll furnish security, lift the attachment order? Why are you making it in this appeal?
Because
Because you have not assailed the order dated 1st July.
No, I have not assailed the order dated 1st July, my lord.
Go before the learned judge.
The first, my lord, until the appeal is restored.
We'll restore the appeal.
Very well, my lord.
Going before the execution court, my lord, has nothing to do with the restoration of a
No,
appeal.
correct.
Kindly keep this pending, let them go before the execution.
But
Restoration will not restore the appeal. Let's restore the appeal, Mr. Mitra.
Yes, I have said.
Yes, they have said. 670 days, no?
999 days. A company, the ground is person concerned, he has left. That's the only.
You know our views, Mr. Mitra.
Not in all cases.
You know. Anyway, have you filed an opposition? Then was direction given? We'll give you direction. We'll file an opposition.
That was, in fact, on the last
the same-
session, the thing was completely different.
That we don't know. I don't remember what happened. Point is that now they say, well, honestly, I did not remember. It was almost 2000 days delay. That I did not remember. Somehow 670 days, what was?
That was while preferring the appeal.
Oh, preferring the appeal.
First default.
I see.
While preferring the appeal, there was a delay of 670 days.
Let them file an objection if they want to. Do you want to? We are not forcing you to file an opposition.
But I had indicated, on the last day, that we will secure. That is why they wanted to take instruction.
I am still agreeable. If they might not pay this 22 crores, I am still agreeable.
22 crores, how is it coming? I have already.
We are not deciding that, Mr. Sen. Today, at least, we are not deciding that. Either you agree.
Now, the council was appearing. They made a commitment before the court that we will come back with the instruction.
I do not.
But if a suddenly different stand is taken, then I will have to also. But adjournment cannot be a ground for change of stand. We must maintain one principle, my lord.
I appeared on that day, when Mr. Sen made the submission
Yes.
of 5.18 crores. I said that I'll take instruction and come back. It was never a concession from my client.
The appeal, the appeal was dismissed for default on February 7, 2020. Stop. The present application for restoration of the appeal has been taken out. Stop. Taken out with a delay of about 1999 days. Stop. Paragraph. The respondent oblique plaintiff seeks time to file affidavit in opposition to this application. Stop. Let such affidavit be filed within a week from date. Stop. Reply thereto, if any, be filed within a week thereafter. Paragraph lists the matter under the appropriate heading. 2 weeks hence.
2 weeks মানে কত হচ্ছে দেখো তো 27
Thank you. 2 weeks since date ta diye dao bracket. আচ্ছা
I'm for the appellant, sir. For the purpose of withdrawal of the amount that has been deposited. I'm for the appellant, Miller. Last occasion, they wanted to take instruction in this matter. Miller, the matter is dismissed for default beyond my knowledge. I filed the restoration application on last Friday, Miller. Yes, Miller.
Then we have to consider that, sir. Have you served?
No, I have not served.
How do you operate, sir?
First of all, my lord, the appeal was filed after the prescribed time period.
No, that's all right, but appeal that relay must have been condoned.
Yes, condoned. They challenge that. They challenge that Supreme Court. That Supreme Court matter is still pending.
The order on condoning delay, you challenge. What happened to that SLP?
That SLP has become infructuous because, my lord, the matter has got dismissed for default.
In the meantime, this is for default, my lord, but that is
preferring a restoration application after, my lord, after more than 30 days.
Yes.
My lord, again they have to file a condonation of delay application, my lord.
That is up to them. We are not
Yes,
going to advise them.
I filed the restoration application along with the section 5, my lord.
You have filed.
Yes.
Serve them.
Yes, I shall serve shortly.
In the meantime, there is no stay of the order that was passed.
Sir, be reasonable. They have filed a restoration rightly or wrongly. If we restore the appeal, then you can't withdraw the amount now. Read order dated July 23, 2025. Paragraph. Learned advocate appears for the appellant and says that an application for restoration of the appeal along with an application for condonation of delay have been filed. Let copies of such application be served on learned advocate for the respondent in course of the day.
I shall try, my lord.
What do you mean you shall try? Why can't you?
Tomorrow, my lord, I shall.
By tomorrow. By tomorrow date ta diye diyo. Paragraph list this matter once again. আজ কি বার বুধবার কবে হবে পরশুদিন
Holiday, my lord.
মানডে না হ্যাঁ on Friday, day after tomorrow, Friday.
Friday holiday, my lord.
Oh, Monday.
15th
Monday.
October, August. Day after tomorrow is holiday, my lord.
So you will not come to court just because it's holiday. You will not. Flag hoisting. Yes, come. Come, we'll just hear this matter only.
I will fix the matter on next week, my lord.
Next week. All right, Monday then.
Wednesday. Next week.
Well, Wednesday. Wednesday, next Wednesday.
Hero, please.
My lord, item number 7, my lord, I appear for the appellant, my lord. We have served them, my lord. This is a matter, my lord, arising out of Order 37, Code of Civil Procedure, my lord. Summary suit, my lord. Before going into impute order, my lord, kindly allow me to make my submission
The case is not open. But I am telling you, Lord, that respondent number 2 has died.
Who died?
Respondent number 2. Respondent number 2 has died. So legally it has to be brought in record.
Soildish particulars. Do the needful, sir.
My lord.
Suit has been decreed. Order 37 suit has
My
been
lord.
decreed.
The net judge, instead of decreeing the suit, what has, my lord, one more thing, my lord.
Who's the plaintiff?
My lord, I am for the plaintiff.
Oh,
my
you
lord.
are the plaintiff.
What has happened, my lord? This was Order 37 suit, my lord. There was
On the basis of what? Guarantee?
on the basis of acknowledgement letter as well as the check, my lord.
I see.
They had not entered appearance within the period of 10 days, my lord. Thereafter, after 2 months, they filed 2 applications. One application was for delay in entering appearance, and another was that this is a commercial suit. Both the application was dismissed by the learned single judge, my lord. and thereafter they had preferred an appeal from that order, my lord. In the appeal, my lord, the learned appellate court had upheld the order, only just made a modification stating that if they deposit the 30 lakhs rupees, only then summons for they would be allowed to enter appearance, and then after summons for adjournment will be given. Otherwise, suit should be heard ex parte. This was the order. They could not deposit 30 lakhs with the original side, registrar original side, my lord. Thereafter, they file an extension application before the division bench, my lord. They were granted 2 weeks more time, my lord, and it was again held. And in case they this time they do not deposit the amount, then the suit to be heard ex parte shall be heard ex parte. After that, my lord, after that, when matter had come before the honorable single judge, my lord, since the time period was not expired, the learned single judge granted an adjournment. After that, my lord, due to change of determination, the matter went before the another court, my lord. Thereafter, there was in the meantime, the matter was kept for orders before the learned single judge. But instead of passing an order, the learned single judge, after change of determination, what he has done, he has stated no. He has, my lord, now let me see the input order. What he has done, he said you first go to the department, see whether the summons had been complied, whether they have received the summons or not, whether it has been complied or not. But as per the provision of law, my lord, if I see whether the summons was served to them, and after they entered appearance, there's a deputy registrar report also, my lord. Lordship may kindly see the impugned order once, my lord, at page 13. And the same was recorded by the previous single judge that the summons had been served and it is satisfied.
Still not deposited 30 lakh.
No, my lord.
Anyway, you do your needful first, get your appeal in order.
My lord.
The learned advocate for the respondents says that the respondent number 2 has passed away during the pendency of this appeal.
Earlier, my lord.
Earlier, has passed away, just passed away.
2024.
He shall furnish particulars. Now, he shall furnish the date of death of the respondent number 2 as well as the particulars of his legal heirs to learned advocate on record for the appellant. When will you give? In course of this week? In course of this week?
My apology for interrupting, my lord. My lord, this is a LLP firm, my lord. One of the partners has died. So, my lord, if other partners are there, my lord.
Yes.
And
so
the
you will not substitute.
all are included over there, as per my knowledge, my lord.
Partner legal pending. Limited liability. That's right. It's an LLP.
The number 2, can you see Jayaprakash Agarwal? He has died.
So his death will be recorded. What else?
Need not to be recorded.
Why should it's a limited liability partnership, LLP. It has a separate juristic entity.
Yes.
But you make an application at least for recording the death. Let something be on record. Maybe there's no need to substitute.
My lord may record his submission that he has given a death certificate.
File an application. Bas, as well as this one number 2, along with a copy of the death certificate to learned advocate for the appellant, that you can give today. Give him a copy of this.
Given copy
in course of the day.
I have given the copy.
Stop. The appellant shall be at liberty to take out appropriate application. Stop. Paragraph. List this matter once again next Wednesday. Stop. If the appellant files any application in the meantime, the same shall be listed along with this appeal on the adjourned date.
I'm grateful, my lord.
Just for recording, but there should be something. But consider, sir, LLP, separate juristic entity, then why were the partners made parties at all?
Partners were made party because they had given the assurance and guarantee to make payment.
Yes, so in that view of the matter, consider if the deceased respondent's legal heir needs to be substituted. Consider the law.
In the meantime, let them give us the details of the legal heirs then.
Give him the
I'm grateful. Grateful, my.
Lordship, in item number 8, the advocate for the appellant is unwell and he is not able to come to court today.
To come. You are appealing for whom?
The appellant.
You are for the appellant. Oh, the advocate on record is unwell.
And the counsel is unwell.
You are the counsel,
No, I'm not the counsel. I'm the junior for the counsel.
but you will argue the matter next day, not today. Yes.
Can we take it up next Wednesday?
Next Wednesday, on condition that you will argue the matter. Accommodation is sought for on behalf of the appellant on the ground that the appellant's advocate on record is indisposed. Paragraph, let this matter stand adjourned and be listed again on সামনের বুধবারের date দিয়ে দাও, comma, retaining its position, comma, on condition that Miss Adrita will লিখো না এটা।
Well, I am for the
Yes.
I am for the appellant.
Yes, Mr. Roy.
Well, this is against an order passed by the Honorable Single Judge, whereby my application for intervening has been rejected.
Application for?
For intervening in the matter has been rejected. Now, this is pertaining to a trust deed of 1934. Now, the trust was.
Have you served?
My land friend is appealing.
My senior first leave to appeal.
Choyunendro. Oh, this is the leave to appeal.
Yes.
Let us see the impugned order once.
My lord.
Coming to this section 7.
Only religious and charitable.
Public check. Yes, are you a beneficiary under the trust?
Malad, I am the great grandson of the original trustee.
Yes.
Malad, the trustees of 1st December 1934. There are certain conditions that have been made in the trust deed. Malad, I am going to place that. Malad, what happened? Malad, the present trustees, Malad, changed the entire scenario of the trust and Malad trying to sell out the properties which was vested in the trust.
How long are the present trustees in management of the trust?
Malad, they are from Malad up on Malad, kindly see Malad, how long they are in the trust. Malad, after the death of the original trustee, Malad, they are in Malad, possession of the properties and Malad, maintaining the properties.
You have not answered our question.
I'm sorry, Malad.
You have not answered our question.
I'm sorry, Malad.
How long?
How long? How long? For so many years they are in position.
Around 20-25 years, I'm
25 years.
around 20.
Have you ever approached the court before, alleging mismanagement, etc.?
No.
No. Suddenly, what prompts you?
Malad, the properties they are going, Malad, they are selling the properties. We came to know that they are selling the properties,
Yes.
which are the trust properties.
If you are not a beneficiary, what locus standi do you
But
have?
I am the.
You are saying it's a private trust.
Yes.
You are saying it's a private trust, which has become extinct.
Yes. Now, Malad, that's why, Malad, I want to place before your lordship certain.
Provided you cross the hurdle of leave to appeal, why should we grant you leave to appeal?
Malad, because Malad, the trust properties, Malad, we are admittedly we are the descendants of the original trustees.
There would be numerous descendants of
Yes.
Bholanath Das.
Yes. Now, Malad, earlier also, Malad, when they are going to sell the properties, Malad, they Malad, noticed us, Malad, we have contested that proceedings. Now, Malad, in that proceedings, there was a compromise because, Malad, we were in possession of the properties as tenants of in respect of it, of the trust, one of the trust properties. Now, Malad, that has been, Malad, sold by them by.
Ki application ache dekhi?
Ships would have to see the trust deed. We have got a bigger photocopy if it helps.
Trustees, main decisions. Can be a man himself. That's the name. 700,000. They're entitled to man himself.
Malad, kindly, I'm sorry, man.
7.
Trust deed.
দাও ট্রাস্ট ডিডটা দিচ্ছিল।
Trust deed is at page 31 of your lordship's brief.
একটা বড় একটা ছোট কেন?
That is our interest now.
One jumbo xerox which we had given, there were two, one which we had already given to this.
Malad, your lordships kindly see the trust deed, Malad, after 8 to 10 lines, Malad, from top. Malad, the line starts with whereas the settler is seized and possessed. Malad, have your lordships kindly got it, Malad? Whether the settler is seized and possessed of the properties described in the schedule here and there, and whereas the settler intends to make provision for the members of his family, kindly take note of it, members of his family dependent on him for certain religious and charitable purposes. In the manner hereinafter expressed, now this indenture with one's witness that the trustees shall stand seized and possessed of the said properties described in the schedule hereunder upon the task following. To then the condition that has been mentioned, what how the properties has to be utilized. Now kindly come to condition the condition 3. Condition 3 last 5 lines. But the trustees, the line starts with but the trustees, I will have got it. But the trustees, condition 3, last 5 lines. But the trustees shall spend the income of the said fund or the part remaining of the said fund for the purpose mentioned in clause 5 hereunder, and the residue of the said fund shall be added to the fund mentioned in part 1 of the schedule hereunder, and the income to be then spent for the purpose of the foregoing paragraphs 1. Now, paragraph 5. From and out of the income of the 5 houses described in part 5 and securities in part 6 of the schedule hereunder, after setting apart out of the gross income of the houses and shares 15% for repairs, the surplus of which will be carried forward from year to year till the completion of the 5th annual repair, to pay all rates and taxes, including income tax of all or any of the trust properties mentioned in the schedule, to pay all establishment charges, law charges and office charges, and to meet the following expenses which shall be subject to the proportionate abatement in case of the balance of the said income falls short to meet all the provisions in clause 5A to 5D. Then in clause 5A to 5D, how the properties to be utilized, that has been mentioned. Now kindly come to clause 6.
To pay for the basic expenses of such of the settlers' sons and sons. Okay. Either sons shall be born 18 years from that these presents and their family members who shall live in place.
When
I am presently 65 years age. 65 years presently.
34,
well,
44,
50,
50,
58, 59.
1952.
Nineteen 65. 1960, yes. Now, kindly similar clause 6. I was placing.
Where do you stay?
Family
dwelling house? No.
Chandan Nagar.
Family dwelling house?
Yes, yes, yes.
Family dwelling house?
Yes.
Back. Join the present appellant. আর বাবা যদি এই ক্লজে কোয়ালিফাই করবে then তার family member who shall be staying at dwelling house at Chandan. তাহলে তো ঢুকে আসছে তাই না?
Not a public trust. It has a private
Maybe certain public charities.
Yes, that is the judgments are there. that you have to immediately reach the conclusion.
Prima facie. Mr. Roy, take your seat. Mr. Gupta, come to, you have a copy of the trust deed? Come to clause 9 under paragraph 5. There are 10 clauses under paragraph 5. Come to clause 9. Read it carefully.
Pay for the mace expenses of such of the settlers' sons and sons now living and dead who shall be born within 18 years from the date of these presents, and their family members who shall live in joint mess at dwelling house of the settler at Chandanagar, the monthly sum of ₹200.
He comes within this clause, prima facie, and therefore it can't be said he has no interest at all.
Could I go a step behind?
Yes.
Their entire basis of their application, I shall show from their pleadings, is that this trust has come to an end. That is the fountainhead of their application, that this trust no longer exists. So somebody who has gone into, come into the control is taking away trust properties. This is the basis of their application. So their case is that trust has worked its way out. I shall show from their pleadings. Two other aspects.
Yes.
Other aspects. Perhaps, if I may use the word, this is possibly a dishonest application. The reason why, there has never been any application in the end till date with regard to the constitution of the trust alleging any mismanagement ever. When this matter, I'm sorry. When this matter ripened to the stage of getting a buyer and selling a fully encumbered property, that at that opportune moment when the sale was to be confirmed, they come up with this application.
Oh, that is why for permission you file section 7.
We file section 7. But the third aspect is there was one other previous property which was sold. They had coerced us to pay around 4 crores, 9 crores, because they were occupying a trust property. To vacate that, they had taken 9 crores from the trust.
And for how much did you sell that property? No,
I shall indicate that.
That doesn't matter.
So they had put us to ransom because they had said that they are in the reply case also. I shall show their pleadings that since they were occupying a trust property, so that was sort of a settlement. So this gentleman perhaps is acting against the
Mr. Gupta, before the learned single judge, in respect of Mr. Roy's client's intervention application, did you file any affidavit?
Yes.
You filed an affidavit.
Pleadings were exchanged. They had filed the reply also. Oh. We had specifically pleaded that this amount was taken. There is no denial. On the contrary, they say, that because they were occupying a property, that is why they had taken that. Other issues, may I just indicate?
Mr. Gupta, we are not passing any order today. We need to see the pleadings. So you file informal paper book. incorporating
all annexed.
all annexed.
The difficulty, my lord, why there is some urgency. We had, my lord, filed this application in 2022. Advertisements were made. We did not receive any buyer. Now, lot of people have conglomerated and have agreed to buy. The Honorable Single Judge had said that there would be a meeting before the registrar original site. The meeting has been held to ascertain the truthfulness of the buyers and so on and so forth. That has been done. If they go away, my lord, then again, my lord, this entire problem.
Where's your stay order? Who's stopping you?
Because of the pendency of the appeal.
Is there a stay order?
There is none. They took the
Then why are you raising these questions?
adjournment on the ground.
That's why, my lord, we are fine.
No stay order. We are not stopping you. File your informal paper book. We'll hear it out next Monday.
My lord, one more thing, my lord. If your lordship was asking me, my lord, what is my locus standi with regard to these properties, my lord, I kindly come to clause 7 of the.
What clause? You can't even refer to the trust deed. You say the trust has come to an end. It's extinct. How can you blow hot and cold?
No, my lord, kindly.
We will not. What is the basis of your application in before the learned single judge? Trust has come to an end. Trust has become extinct. That is recorded by the learned single judge.
My lord,
Then how can you rely on the trust deed?
Kindly, my lord, kindly.
How? Why?
My lord, I am the descendants of the original trust.
File your paper book. How soon can you file, Mr. Ghosh? Monday. Then Wednesday we'll hear out.
Only thing, all the papers are already annexed to the application, but
Oh, annexed to the application.
only the ATA is not. Only our application is not annexed because they had filed an intervention application.
We should have everything in front of us.
As your lordship is.
We have heard learned counsel for the parties for some time. Another kotha. Stop. The intending appellants intervention application filed in connection with an application under section 7 of the actor
Religious and charitable trust.
religious and charitable
And
religious trust act 1920 has been dismissed by the learned single judge. Stop. That order is under challenge in this appeal. Paragraph. We propose to hear out the appeal. Stop. We propose to hear out the appeal and the connected application together. Stop. Let the intending appellant file requisite number of informal paper books
by Wednesday. Just as
by Wednesday, my lord.
By Tuesday. Incorporating therein all papers that were available before the learned single judge. Stop. All single judge, by next Tuesday date though. With copy to learned advocate on record for the you appear for all the respondents. Copy to learned advocates for the respondents. Stop. All formalities are dispensed with. All respondents are represented. Stop. Since all the respondents are represented through learned counsel, notice of appeal is deemed to be waived. Paragraph. List the appeal on Wednesday date though, next Wednesday. Stop. Wednesday.
Indulgence, if your lordship kindly considers, we had not served a copy of the main ATA, the main application, because they had filed an application for intervention. Is it your lordship's pleasure that we should prepare a supplementary informal paper book? With that, we shall not give them the copy.
Yes. Bring it.
I'm good.
Say that there is no stay.
No. But there isn't.
There isn't, but on this ground, they have taken an adjournment.
1 week, Mr. Gupta. 1 week.
Nothing.
Matter will appear on, I think, Monday.
Wednesday.
I'm grateful.
I pay for the appellant. All the more reason no reply is required if it's a point of law. Rashid, may I?
Well, not, but the thing is, at this juncture, when the document has been exhibited in evidence, examination and process.
I've not even started. May I open my case, my lord?
Founding has been granted to that particular document. Can they withdraw that document or not at this juncture?
Withdraw. There is no question of withdrawal. My lord, may I indicate what is the order, my lord? Lordship, in a suit for recovery of possession, Lordship, we got a decree way back in 2011, 2012. Thereafter, my lord, the decree was set aside. Lordship, we are the plaintiff, my lord. The decree was set aside, saying that they should be given a chance.
What kind of a decree? What decree?
For recovery of possession.
Yes.
Lordship, the possession was given to the defendant in lieu of an agreement to sell. The agreement to sell was exhibited at that point of time. They were not appearing. Although they filed the written statement, they stopped appearing and that was exhibited. Thereafter, my lord,
It was impounded. Mr. Ali,
Lordship,
the order impounding the document was 30th of April.
Lordship.
That has not been challenged.
No. We are not challenging that.
So
That has been
you will
impounded.
not pay the registration fee, the stamp duty.
Lordship, if I do not pay,
you will not be relying on that document.
Lordship, that was the submission I made. But my lord, it was Lordship's opinion that this be tested. I am only on the last sentence of page 70 to the impugned order. Lordship will see. In terms of the report of the collector, the plaintiff shall take necessary steps to pay the registration fee and stamp duty. First of all, it is only for stamp duty. Registration fee is not even part of impounding. Second of all, my lord, stamp duty, Lordship, I categorically submitted on 3 occasions.
What is this document?
This is the agreement of sale on the basis of which they have got possession. My lord, the fact that they are in possession with respect to, in lieu of that agreement to sell, that is admitted. The fact that they did not pay the balance sum, that is admitted. Within that 6 months period, that is also admitted. So, Lordship, this in view of all the admissions in the written statement, I need not rely on the agreement of sale. There is no counterclaim. So, my lord, if at all anybody needs to rely, it's the defendant who has to rely.
So, how can you force him to rely on a document, madam?
The entire examination of the witness has taken place on the basis of that particular document. Today, when they are saying that we will not rely and we will not impound that particular,
No,
we will not pay the stamp duty.
Where is the provision where you can force him to pay?
We are not forcing them to pay. It is just my humble submission before the Honorable Court that it is the plaintiff's document. So if impounding has to be done, if there is an order for impounding, it is their document. They are liable to pay the stamp duty. If they are not willing to pay, then the chance should be awarded to the defendant in that case.
What should be awarded?
The chance to pay the stamp duty and registration charges, because if they do not
pay,
we are already relying on their document. The defendant.
So who is stopping them from paying?
So who's stopping you? Go and tell, pay. Who's stopping you? How can you force the plaintiff to pay if the plaintiff says, I don't want to rely on that document? I will not pay stamp duty. There's no provision in law.
the entire
Yes.
on that particular agreement for sale. That is
You rely on it. You're a party to that document. You go and pay stamp duty. Who stops you?
I'll take out.
But we can't, no, but the court cannot force him. He cannot rely on it. He doesn't want to rely on it. Issue.
And my lord, from since January, my lord, the action has been closed in December. And thereafter, lordship, who will pay the stamp duty? That is the thing which is going on. Lordship, the arguments are supposed to start.
By consent of the parties, now, since the point involved is a very short and simple one, comma, by consent of the parties, comma, the appeal and the connected application are taken up for hearing together. Paragraph. An order dated July 28, 2025, passed by a learned judge of this court in CS 283 of 2011, is under challenge in this appeal at the instance of the plaintiff. Stop. The order is a short one and is reproduced hereunder. এ থেকে মেমো থেকে ব্র্যাকেট করে দিচ্ছি। Paragraph. The document in question, i.e. Exhibit A, which was impounded for being insufficiently stamped or not stamped at all, or what was it? Insufficiently stamped, is an agreement for sale of the suit property. Stop. The plaintiff says that on the basis of that agreement of sale, agreement for sale, agreement of sale, the defendant was put in possession of the suit property. Stop. She says that she does not wish to rely on Exhibit A.
He. Acha, Sufia Khatun. Oh, yes. Sorry. I thought.
On Exhibit A. Stop. Hence, he cannot be, she cannot be compelled to pay the stamp duty. Stop. Paragraph. Learned advocate for the respondent oblique defendant says that examination in chief and cross-examination was conducted on the basis of the concerned document. Stop. At this stage, the plaintiff cannot say that she shall not rely on the said document. Stop. Hence, the plaintiff must pay the requisite stamp duty. Stop. The defendant wishes to rely on the agreement for sale. Stop. For sale, off sale. For sale, off 19 for sale. Stop. Paragraph. If the agreement for sale was insufficiently stamped, the same was liable to be and has been impounded by the court in terms of the provisions of the Stamp Act 1899. Stop. If the plaintiff wishes to take any advantage of the document in question, she must pay the requisite stamp duty as assessed by the collector. Stop. However, if the plaintiff says that she would not rely on the document, she cannot be compelled to pay the stamp duty. Stop. She would then be precluded from relying on that document. Stop. Hence, paragraph, hence, comma, we are unable to sustain the order under appeal, stop. In any case, comma, in any event, comma, no question of payment of registration fee can arise, stop. Even the stamp duty which the plaintiff has been directed to pay by the learned single judge is not mandatorily payable by him so long as he does not wish to rely on that document. He, no. So, paragraph. If the defendant wishes to rely on the concerned document, comma, nothing stops the defendant, comma, who is a party to the agreement for sale, comma, to regularize the document by paying applicable stamp duty. Stop. The defendant will be entitled to do so. Stop. Even then, comma, the plaintiff will not be entitled to rely on the document.
Just one thing, the assessment that has been done by the collectorate, it has been assessed as on date and not at the time when the document was executed. So if that could be recorded here.
Cannot go into all that. We cannot. If you have a,
Regarding the last line, my lord.
yes, you have not challenged the order. You have not challenged the order. If you have any grievance, go before the learned single judge. You were saying something?
Regarding the last portion, that even then I will not be, Lord, once it is exhibited, nothing can stop me from relying on an exhibit.
No. You can't take advantage. Then you pay.
No, anyway.
Then you pay.
Anyway, I do not wish to.
But you said you don't need to rely on it because everything is admitted.
I only
Paragraph.
need the possession.
Your ground 3. Look at your ground 3. You can't have it both ways.
I have said something.
Stop. In this connection,
question of withdrawing.
In this connection, ground 3 of the memorandum of appeal may be noted, comma, which is to the effect colon দিয়ে এই ground 3টা কোট করে দিও। হ্যাঁ ওই যেখানে will not be entitled, is precluded from relying নাকি বলেছি না এলা, except for collateral purposes, which is the law. আর এই ground 3টা দিয়ে দিও, যে একটা বললাম, দিয়ে paragraph, the appeal and the connected application stand disposed of accordingly.
Actually, this suit is fixed for arguments, Lordship, on 25th. My lord, the arguments may.
We have not stopped anything. We have not stopped anything.
The defendant is supposed to start. The defendant.
Yes, we have not stopped the suit.
Very well. If Lordship may clarify that the arguments may proceed.
We have not
very well.
said anything.
Very well. Great.
বলবে কিছু? হ্যাঁ ইয়ে করে দিই।
Over 12:15 fix করা আছে 12:15 একটা fix করা আছে
Mr. Ghosh,
Yes.
normally we rise at 12 o'clock. So we don't want to interrupt you after 5 minutes. So we'll go, come back, and we'll take up your matter.
Item number 11.
May it please your lordships.
Mr. Ghosh, just to assess the situation, roughly how long you will take till recess?
Yes, yes, certainly.
Easily.
Easily.
Oh, till 12:45 because we have something else fixed
Yes,
at 12:45. Other matter release করে দাও তাহলে এটা আর ওটা ছাড়া। কি বললো মাথা মুন্ডু
একটা 15 হ্যাঁ তাই তো 115 অব্দি The way we would like to structure my argument, my lord, give you a bit of a factual background on how it all started, then come to, because today, my lord, the challenge to an award is in a very small compact, very small grounds, and that I have to come within those grounds and nothing else under section 34. So I'll have to show, I'll take you, lordship, to the majority award to show where the majority has breached, and I'm coming within those grounds. Then, my lord, and also the minority award, and then place the case laws. That's the way I would like to proceed. My lord, your lordship had heard that Sale, the respondent, was importing huge quantity of coal and coking coal from abroad. Huge quantity for its steel mills. Now, with that object, VSPL approached Sale that we shall handle your cargo at Vizag if we import through Vizag. And there was first, it was agreed that there would have to be the draft is to be of 14 meters, that is 42 feet, because these cargo is imported in Panamax vessels, these huge vessels. They require 42 feet draft. With that basis, they entered into a long-term agreement because the VSPL has got a license from VPT to construct two berths, EQ8 and EQ9, for having a deep water draft. And with that, they entered into a long-term agreement. They obtained a license from VSPL, which is appellant before your lordship, obtained a license from VPT for a period of 30 years.
13.
No, 30. And this is on BOT basis. Build, operate, transfer.
Build, operate, transfer.
This is very common, my lord. I did this matter with the Nivedita Bridge connecting Damdam to the Kineshore by L&T. That was also on BOT basis. Because they build it. When they operate, they recover the money.
Toll.
Here, my lord, it's a question of paying the storage charges and everything. They recover the money and then they transfer it. Okay. So this was for so when they were built these two berths, they could not finish 14 meters draft. So the appellant, VSPL, entered into a short-term agreement, which will be for 1 plus 3 years. With an option, we renew it for further year. Now, with that basis, the agreement was entered into, and those clauses are important because they have not been placed by the appellant, naturally, and they were operating, so they had right to enter into a contract with third parties since they were operating on their own terms. On their own, it's a private contract that is recorded in the award, both in the majority award and in the minority award. when they brought up the question of TAMP, I was appearing for Steel Authority. I said, if you're asking for TAMP, TAMP has an arbitration clause. Let us go to TAMP. They said, no. This is a private contract between VSPL and SAIL. And that's been recorded by the arbitral tribunal. Fine. We went, I didn't, we still let it rest there. Then, today let us make it very clear, instead of going through all these, we have paid all the ITSC charges. My Lord Justice Rai was not there. It's called Integrated Terminal Service Charges, which is composite of 167 rupees per ton. There's no whisper in ITSC of any payment of any demurrage, because that was a composite amount. If they wanted something more, that should have been mentioned. That is subject to whatever demurrage charges, or whether they were paying demurrage to VPT, and in turn asking us, there is no record they paid any demurrage to VPT. Because they've got a license, there's no debt. And that's the first thing your Lordship asked the appellant. So have you paid any demurrage charges to VPT? They couldn't produce any document. That was nothing was on record today. Then the matter was only nothing is even payable under ITSC. For 4 years, we've imported coal and coke through Vizag port. Only then, only in 2010, they came up with this idea that you have to pay demurrage. And SAIL said, what for? There's no clause for payment of demurrage. We will not pay any demurrage. On this question of demurrage, they went to arbitration. And this huge amount they're claiming. Now, my lord, the majority naturally went, they were against me. And minority was thoroughly dealt with all the points. Why did a trial judge inclined towards the minority award? All the points have been dealt with. Nothing.
Majority was against you?
Yes.
Achha.
Minority was
so single judge upheld the minority.
We cited it because there are judgments. In Seven says itself is where they said, following builders, Seven's case is
No. It can be done. We are not on that. Factually, we are.
Factually, yes.
Because it can be done.
There are other judgments also.
Yes. That is a...
Now, before the two.
Yes.
Before 2015, amendment of the Arbitration Act. This is now some legal background giving, my lord. The grounds upon which it all started with Rendushagur's case versus Electric Company in 1994. That's when it started. But that was for enforcement of a foreign award. But the question of fundamental policy of India. But when the Arbitration Act of 1996 came, they spoke about the fundamental policy of India and the justice, morality, and interest of India. The first important judgment after the 1996 Act of Arbitration Act was ONGC versus Saw Pipes. And she was aware of it. So, no, we should contact. ONGC? Just look at that. All the DGK, ONGC এখানে আছে DGK বলো আচ্ছা তুই তোমার দেবো কপি দিয়ে দেবো Yes. Now, Sawpipe said that they laid down the arbitral tribunal must follow substantive law of the land. Now, what is substantive law of the land? They said Transfer Property Act, Contract Act, Sale of Goods Act. These are the substantive law of the land to follow. Then, if the arbitral tribunal must not act contrary to the interest of India, then the question of justice and morality was there. And ONGC's case, Supreme Court said, Justice Shah said, and if it is patently illegal. For the first time, it came that patently illegal point. Well, then came the next big important judgment was Associated Builders versus Delhi Development Authority.
What was ONGC's year? Year 3. And Associated was 2015.
2015.
I cited Associated.
Associated Builders, substantially, and they said so. They followed ONGC's thing. But Associated Builders said that the judgment was delivered before the 2015 amendment of the Arbitration Act. In the amendment of the Arbitration Act in 2015, this 2A was added, 34(2)(a), the patent illegality on the face of the contract, really borrowing from ONGC versus Sawpipes. That was an additional ground which was added. And that was dealt with in semi-amnesty. Then we read now the question was, what is public policy and fundamental policy of India? Very unruly horse. Who determines public policy? It all comes down from time to time. What do you think of public policy? But Supreme Court laid down some guidelines. These are the public policy or fundamental policy of India. From the various judgments, which I can tell you, Lordship. There, one of the things is the tribunal cannot go against any specific term of the contract, 28(3), but within the parameters of the contract. You cannot go beyond it, otherwise you can't rewrite the contract. What practically the appellant was asking your lordships to do. VPT, VSPL, everything. We don't have any. I have primitive contract with only VSPL. We didn't go to TAMP or anywhere. What they were doing, when they were challenged by us, where is this TAMP? Then they produce some of the TAMP's notifications. The other point is, the tribunal must apply its mind to the attendant facts. Must apply its mind to the attendant facts. Non-application of mind by the adjudicating authority is itself against the fundamental policy of public policy of India. That's how, because I shall be taking these grounds. If the award is based on no evidence, then it is to be set aside, or at least that portion of the award. The tribunal must take into consideration all the important documents which are relevant for the purpose of adjudicating the dispute between the parties. And this is the first point I shall be taking.
Yes.
And if the tribunal ignores a vital evidence in arriving at its decision. So I have to fall, my lord, under one of these grounds. Come within public policy of India, fundamental policy of India. what I could find from the records below, that VPT had granted a license to VSPL, the appellant, for the period of 30 years from the license agreement was dated 28th November 2001. For construction and operation, management and maintenance of two multipurpose berths, EQ8 and EQ9, in the inner harbor of Vizag Port.
Yes.
For a period of 30 years on BOT basis. This was a multipurpose berth, EQ8, for handling coking coal and metallurgical coal. At the said berth, which stipulated draft of 14 meters. If failed, in any case, we entered into a short-term agreement on 6th May 2008 on the terms and conditions contained in the said document. Your Lordship will take the short-term agreement. Huh? Short-term agreement is referred. Eviction should not want to go for it. Please.
Page 64, volume 1.
Sure, Well, may I trouble you, Lordship? This is short-term agreement, hereinafter referred to as the agreement, entered on 6th May 2008 at sale office in Kolkata. And this gives the ability. Kindly turn over the page below. Whereas the Board of Trustees of the Port of Visakhapatnam, namely Visakhapatnam Port Trust, under the provisions of Major Port Trust Act 1963, hereinafter called VPT stroke licensor, has entered into a license agreement on 28th November 2001 with VSPL as licensee, as license agreement for construction and license out equipping, operation, management, and maintenance of two multipurpose berths, EQ8 and EQ9, in the northern arm of the inner harbor of the Vizag port for a period of 30 years for handling coal, limestone, rock phosphate, sulfur, and other bulk of general cargo or container or liquid bulk cargo on build, operate, and transfer basis. So if they built it, now they're operating it. To recover the money from me. Whereas SAVE is the largest integrated steel manufacturer in India and the public sector undertaking, SAIL owns and operates 5 integrated steel plants located in Bhilai, Sweden, and so far I did a trouble not sure. Whereas the agreement of dated 31/1/2005, hereinafter referred to as the original agreement for a period of 30 years, was entered by the parties herein for integrated terminal services at multipurpose berth EQ8 for handling of coking coal and metallurgical coke at the said berth, which stipulated draft of 14 meters as per terms and conditions contained therein. And whereas the shore handling system has been installed by VSPL, that's the appellant, but the requisite draft of 14 meters for berthing a fully laden Panamax vessel could not be achieved for the purpose of execution of the job strictly under the terms and conditions of the said original agreement. Within the stipulated period of 24 months, the parties are entered into this. Then came the short-term agreement. Whereas VSPL requested sale for considering some alternate arrangements as per the draft available at the berth of Visakhapatnam port, so that the facility can be availed by sale for handling of coking coal and metallurgical coke, and accordingly requested sale by its letter dated letter number so-and-so, dated 6 November 2007, forming integral part of this agreement for entering into this agreement for a period of 3 years with a provision for extension of 1 year at sales option on terms and conditions contained therein. Now, my lord, just to cut them at short, my lord, kindly come to 1. My obligation under the agreement was, in the first year, I will give 0.75 million tons of cargo for handling. For the subsequent years, for 3 years, I'll give 1.5 million tons minimum. It may go beyond. So, that your lordship will find in clause 1.1. And there's no dispute about this. There's no dispute that we didn't give. In fact, we gave them more. My lord will kindly come to page clause 1.2. What is applicable to sale? Assurance on cargo and cargo volume. Sale assures an import cargo volume of 1.5 million metric tons per annum to VSPL, berth for a period of 3 years from the date of signing of the agreement or extended period if any. However, the penalty shall be applicable and payable by sale to VSPL only if the cargo volume falls below the stipulated level. That is, if it falls below 0.75 million tons or from second period, year onwards below 1 million tons. Sale will be penalized. Again, this clause is not really material because there's no question. We have given them far more, far more. Then comes, my lord, the agreement period. Clause 2 is the agreement period, which means period of 3 years from the date of the agreement, extended for a further period of 1 year at the option of sale. The berth means EQ8. All these men not necessarily real. I not trouble you, lordship. Kindly come to the internal page 10 of that agreement at the bottom, the license agreement and integrated terminal services. Kindly come to that. Just skip over 2 pages. You've got to. Please. Integrated terminal service charges. Have you found it? Means the consolidated charges payable by sale to VSPL for integrated terminal services payable on 99.5% of the draft survey quantity or the actual quantity dispatched to the steel plants of sale, based on payment whichever is less, to be carried out as per the agreement which will include all cargo-related port and other incident. Kindly make a note, Miller. All cargo-related port and other incidental charges payable to VPT by sale for its imported cargo and coal. Nothing else charged. Nothing. We never used anything because the moment the cargo was discharged, everything was handled by VSPL from hook point right up to the storage point. From storage, the railway rakes came, they loaded them in the railway rakes, it went to the various steel plants. SAIL never touched anything. Then, license agreement means the agreement dated 28 November 2001, including Appendix 1 through 21, entered between VPT and VSPL as may be amended from time to time. Now, may Lord kindly come to clause 3.3. This is very important. Based on the minimum discharge rate of 20,000 metric tons per day, the berth can handle the cargo volume up to 4 million metric tons, approximately 210 to 220 days in a year. The cargo volume of 1.5 million metric tons spread over 12 months can be comfortably handled with adequate buffer provided for maintenance, possible bunching of ships, and breakdown, including force majeure clauses. Therefore, kindly see, therefore, VSPL warrants that the cargo assurance by sale to VSPL of 1.5 million metric tons on a year-to-year basis during the agreement period of 4 years can easily be handled by VSPL. VSPL confirms, my lord, confirms that 40,500 square meters of area will be utilized for handling the cargo and merchandise handling facilities, drains, etc., buildings, etc., associated with providing integrated terminal services as per this agreement. This is the area dedicated to sales cargo. 40,000 square meters. So this is very important clause, my lord, which perhaps was not shown to your lordship at that time. Entered this after negotiation that no, we can handle 1.5 million metric tons, and we're giving you 40,000 square meters exclusively dedicated to sales cargo. Now, my lord, integrated terminal services. SAIL issues a minimum guarantee of 1.5 million metric tons per year for inner harbor handling each year or operation throughout the agreement period for actual quantity handled up to 1.5 million tons. The ITSC payable shall be 167 per metric ton for the first year of operation. In case of any shortfall in handling less than 0.75 million metric tons, then for such shortfall quantity of cargo, SAIL shall make by way of penalty to VSP at the rate of 119. In any case, the main point is it has to be 1.5. It never fell below, never fell. So kindly come to 4.3, 4.4, 4.5. Annual volumes. Sales should
Yes, Mr. Wood.
annual volume 4.3, my lord.
Yes.
SAIL shall provide VSPL the information relating to likely annual cargo volume before the beginning of each financial year, that is by February, and the same shall not be less than the cargo commitment of 1.5 million metric tons by sale to VSPL, subject to such review as provided in Clause 8. This is an important clause I'll be coming to. Monthly volume. So annual volume, then comes monthly volume. Sales shall advise VSPL the tentative monthly cargo arrival plan, preferably 10 days prior to the beginning of the month concerned. Then 4.5, sales shall endeavor to advise 10 days prior to the arrival of the vessels their estimated time ETA of roads of VPT VSPL shall prepare themselves in all respect to receive on a month-to-month basis the specified number of vessels after their lighterage at GCB means General Cargo Berth. GCB. Or any other port berth moving out of it, or whatever it is. Now we will come to the clause which has been the subject matter of the dispute, that is 5.12. Storage and stacking. VSPL shall ensure storing of the cargo grade-wise up to a maximum of 4 grades and maximum cargo volume of 60,000 metric ton in case VSPL, in case of exigencies, endeavor to accommodate cargo of a further 30,000 metric ton for a period not exceeding 15 continuous days. There can't be any break. "15 continuous days. However, sale shall give 30 days notice to VSPL to organize stacking requirements of such higher cargo volumes. If the cargo commitment by sale to VSPL, my most important word is expected to go beyond 2 million metric tons, VSPL shall organize storage of cargo up to 90,000 metric tons with a further provision of 30,000 metric tons of coal in exigency for a period not exceeding 15 days. So if it is expected to go beyond 2 million tons, this is important, my lord. Because there is a course. Because during the course of the argument before the tribunal asked that what was the cargo volume handled each year by VSPL? Both parties were ad item. Cargo volume one we took from financial year, they took from something else. But okay, we all came to the same conclusion. It was, once it was exceeded 2 million metric tons, once it was 1.96 million metric tons, 1.86 million metric tons, so it was expected to go beyond. And that's what, but there is no reference of this in the majority judgment award. Such a vital document. But in the minority document award, it has been thoroughly dealt with. I'll show your lordship when I come to the award. Now kindly come to, my lord, clause 8. Review. SAIL and VSPL agreed that for the first 6 months of operation of this agreement shall be treated as a test period of the assessment of the actual quantity of cargo that can be made available to VSPL terminal and to test the operational parameters, after which the terms will be revised. If they wanted to revise the terms, they are asking me to pay from 2009 February. This meeting the meeting was to take place after 6 months. It took place in October 2009. I'll give you lots of that. And if required, terms and conditions will be further revised. They could have introduced. You have to pay demurrage. That meeting, not a whisper. It was to take place. Yes, so it should have taken place after 6 months, November 2008. The review meeting.
2010 October 9 October date.
Yes. Now kindly take the first annexure. Integrated terminal services for the guaranteed cargo quantity of 1.5 million metric tons shall be 167 rupees per metric ton, including power element for the first year of operation. The ITSC comprises of various elements, both escalation or escalable and non-escalable. The ITSC shall be subject to escalation, if any, at the beginning of each subsequent year for operations for royalty, lease rentals, power, and shall be on actual as per VPT notification and Andhra Pradesh Electric Corporation notification. We could have easily made the contract subject to VPT or TAMP rules and bylaws. Whole I need not trouble you, Lordship. Whole document, if you see, there's no whisper of any demurrage charges to be paid. Integrated terminal service charges is a consolidated amount. Nothing less, nothing more, nothing less. If I give you less, I shall be penalized.
Yes.
Kindly take below the breakup of ITSC. That's para 6. Power. It's as per Andhra Pradesh electric supply, it will be 5.44 per unit for high tension. This is only 8% of the total. Royalty. VPT TAMP notification warfare of rupees 26 per metric ton and 17.11 thereof. Lease rentals, according to VPT TAMP notification, 4733.40 per 100 square meters per year. Others, 36%, RBI bulletin and all this, non-escalable, 53%, total 100%. Nothing, they don't say anything about the demurrage. Following, everything is written out there. No case of demurrage will be payable as per VPT or TAMP mentioned here. ताज्जुब এটা কোথায় রিভিউ মিটিংটা কোথায়
139 page 139 page 139
New meeting.
8 point.
139 page of the first volume.
Volume 1, P 139.
Review.
Review. That's why I showed you, Lordship, that there will be review. First 6 months will be taken as a test period. Clause 8, yeah? Clause 8. May I read out the clause 8 once again, Your Lordship? I'll just read out. Review. SAIL and VSPL agree that for the first 6 months of operation of this agreement shall be treated as test period to make an assessment of actual quantity of cargo that can be made available to VSPL terminal and to test the operation parameters, after which the terms will be reviewed jointly and if required, terms and conditions will be further revised. Now, first 6 months, Milord, should have been in November 2008. This is taking place in October 2009, after 18 months. Now, kindly come to Milord. This is written by Steel Authority to the appellant. This has reference to review of the above STA as per clause 8 of the said agreement. In line with the discussion held between SAIL and Vizag Seaport, the following points have been agreed. Rate up to 1.25 million metric tons. 160 million, that I need not trouble your Lordship because nothing. Now your Lordship will see that they reduce the rates. Rate above 1.25 million to 2 million, it will be 162 from existing 167 because they're getting more business. Above 2 million to 3 million, it will be 135 instead of existing 167. Above 3 million, it will be 97. Then we'll kindly take the last paragraph, paragraph 3. SAIL confirms the availed services of VSPL for stevedoring operation at DCB during the rest of the period of STA under the original terms and conditions. VSPL will be obliged to undertake light storage operation at general cargo berth for those vessels which will eventually proceed to VSPL berth for inner harbor operation. For handling other vessels at GCB, VSPL will undertake such operation rates and terms will be separately negotiated with SAIL, with VSPL. The committed discharge rate for the purpose of application of penalty shall be calculated considering the discharge rate at GCB and VSPL berths together. Nothing but terms. Then, my lord, your lordship will not find many mention of demurrage. They have the opportunity to revise the terms, to bring in that, look, you are not giving me notice as required under 5.12. You have to pay demurrage for longer storage of cargo. They couldn't say that because it was their duty to store and sea onward transportation of cargo to the various steel mills of SAIL. Then, this letter shall form part of short-term agreement dated 6/5/2008. All other terms and conditions shall be as per STA. In the humble submission, it does not lie anymore for the appellant to contend that they should that SAIL is liable to pay demurrage. Whatever it is, stamp, VPT, VSPL, whatever it is. They're trying to say this is what VSPL with VPT, therefore VPT with VSPL. Doesn't matter. Here was opportunity for you. You never raised a whisper. On the contrary, you're reducing the rates because you are giving us so much. ঠিক আছে চারটা কোথায় আছে চারটা দাও কোন পেজ পেজ 96 আছে দেখো তো ভলিউম 1 চারটা পেজ 96 বাদ তো দেখবে পেজ 96 দেখো তাই রাখো Okay, volume 1 to talk to spiral. Volume 1.
Mr. Ghosh, a matter is fixed at 12:45. So we'll resume again.
2 o'clock.
Sure, it position, it will retain its position. This is commercial or non-commercial?
Non-commercial.
So in all possibility, next Wednesday. In all probability, next Wednesday. Earlier is unlikely. It will run in the list.
We're not taking to at 2 p.m. today.
Today?
I'm asking you.
কিছু আছে? Continue. Yes, we can continue.
Yes.
We can continue.
Yes.
Very
we can
well.
keep the continuity.
Yes, yes. Sorry, yes. Please come back at 2 p.m. then. তাহলে এখন কিছু লিখো না। হ্যাঁ? কেন কি করবে দেখো তোমাকে তো
না ধরো একটু দিয়ে যাও এখানে লোক আসবে
I think for 5 p.m. Item number 70.
Should I appear for the appellant in this matter? On the last occasion, your lordships were pleased to observe, in fact, direct the parties to obtain instructions as to whether the parties are agreeable for a formal mediation.
Yes.
My instructions are that my clients are agreeable for a mediation. So it depends on what the response is from the other side, because it was clearly understood that unless mediation happens, the appeal shall proceed.
Yes.
Otherwise, I should press the.
What is your instruction?
It's not possible, Millard. I've asked them for mediation. They have to come down from France, Millard, to mediate. It's not possible.
Language barrier.
There's a language barrier here, Millard. They say, Millard, it's pending. They say so, Millard.
Mr. Ghosh, we cannot force your client.
They have said so. I've taken the instruction, Milord. It's Lordship will hear us
Very
out.
well. These factors should weigh at the time of, awarding costs. This is a suggestion. The time of awarding costs. Proceed with the appeal.
Yes.
We'll record that they are not agreeable.
Not agreeable. তাই তো instruction তো। Outside court settlement, if they give us an offer, we can agree.
No, there's no question of an offer. Talks of settlement are going on for the last 2 months. There has been no positive response from the other side. It cannot be open-ended. Talks of settlement cannot be open-ended. It is going on for the last 2 months. Nothing.
That will
positive has come.
outside court settlement, Milord, I am welcome, Milord. But
It
Milord,
can go on parallelly also. If it is settled, we'll
Milord, I do. With the lawyers, we have no difficulties. Milord. Every lawyers are there.
But Milord, the matter cannot remain pending.
No, I have not said so.
No, we'll proceed.
Yes.
Let us allow us to go through the impugned order once.
Yes.
You appear for both the defendants.
Milord, I appeal for the plaintiffs.
Oh, you are for the plaintiff.
I am for the plaintiff.
I am for the defendant number 1 in the suit and the appellant here.
Who is for the other defendant?
Milord, the other defendant has expired in the
Oh.
meantime. Perhaps a formal deletion may be necessary, but it has not been done by the plaintiff as yet. Well, the impugned order.
We are reading it, Mr. Chatterjee. Yes, Mr. Chatterjee. The only point is, it is no more in dispute. Mr. Ghosh will not dispute that the court has the power, although it says not later than, or not more than 90 days or something like that, not beyond 90 days.
Because it's a old Miller. I don't know. I'm sorry.
No,
It's non-commercial.
It's
Yes.
a non-commercial.
Yes.
It was supposed to be a commercial matter. Appeal has been now preferred in the commercial division. It's a commercial matter. Miller, there's a distinction to the judge.
May I address on that? Because that will be the principal bone of
It's not appellable. Miller. It's not appellable.
That will be the
This is this is filed in the
Not
commercial.
applicable.
No, this has been filed in the commercial division.
Trademark appeal.
This was a.
It's a now Miller numbered as a
for that,
commercial
Miller,
suit.
I have to address my lord.
It's not appellable.
Miller, this suit was filed originally before
Order
the Commercial
43.
Courts Act was enacted. Thereafter, the suit stood transferred under Section 15 to the commercial division. And at the point of time the impugned order was passed, the suit stood transferred to the commercial division. But this application for extension of time to file written statement on which the impugned order has been passed was considered, entertained, and decided in the non-commercial division. Therefore, Millard, my fundamental point is that on the date the order was passed, which is 28th of March 2023, this honorable court, in exercise of its commercial jurisdiction, could not have entertained the application at all, and therefore the order is without jurisdiction. In the non-commercial side, it could not have been entertained in the non-commercial side, and therefore the order is without jurisdiction. That will be my fundamental point. That will be my fundamental. Because the suit stood transferred.
Correct.
And
Non-commercial.
Millard taking Millard both
yes.
matters. So
And
it
my
appeared
submission will be that the-
appeared in this read. So it's a question. It's not a question of inherent lack, because that persona Millard designator Millard persona had it Millard.
Millard,
So
my-
he had both. I'm sorry. I'm sorry. I am sorry.
Millard, he-
We have followed. We have followed.
Yes, Millard, and my submission is that he is not the persona designator because the incumbent doesn't matter. It's the question of the jurisdiction which has been exercised. The same learned judge can exercise various jurisdictions, and various different provisions of law may fall for consideration when the same learned judge sits in different jurisdictions. So therefore, it's a question of not the personnel of the learned judge, it's a question of the jurisdiction he is exercising as at a given point of time. And therefore,
and the transfer had already taken place.
Yes,
So
yes.
Millard, if he placed in a wrong list, I can maximum.
yes, transfer
with
had
it
taken place.
had
That is
taken
the whole.
place.
That is the whole issue.
So it's a commercial matter.
Therefore,
in effect.
assuming that the learned judge, accepting my learned friend's argument that it's a formality and the learned judge had both the jurisdictions, then the question will arise that Section 15(4) of the Commercial Courts Act ought to have been taken into consideration. It could not have been disposed of without adverting to Section 15.
You address us on that score. I think it is better.
Kindly take, Millard, the Commercial Courts Act for a moment.
Oh,
The availability, Millard.
Availability is a
Also
point
of
of
the
demerit. In that
availability.
case, let my learned
Learned
friend argue.
friend has
argue
to
that-
first satisfy this is appellable, because lordships
I don't have to satisfy. If the demerit is taken,
No,
let
I
him
am taking
address.
it's not appellable under under
That's the
section
point of
13. Millard.
demerit.
What more I need to say, Millard? It's a order 43 is only Millard, doesn't prescribe Millard.
No, but this order has been passed in the non-commercial division.
In order has been passed in a commercial matter, in a non-commercial.
The non-commercial division.
But Millard, the suit as on that date was a commercial suit, and the appeal is in the commercial division.
Nonetheless, the order was not passed on the commercial division. Right.
Non-commercial order has to be in the non-commercial.
Therefore, latest patent appeal may lie. We have better points. Why you are going this?
Address your lordship on the basis
In that
of the
given
legislation.
matter, Millard, I thought, Millard, notes are ready. I want more senior person to appear, because this is a latest patent. We are, Millard, governed by latest patent. It was the act of the Millard Crown. By subsequent legislation, Millard, that power, when my rules were not before the parliament, it cannot be taken away by a subsequent legislation, Millard. This argument I want, in a given matter, a much senior person to argue. My notes are ready. Someone has to argue.
But then the provision has to be challenged. The particular
Not necessary, Millard. That is because Delhi, Madras, and Bombay rules were placed before the parliament, but unfortunately, Millard, our rules were not placed. So, Millard, without that, sir, Millard, I want, Millard, some senior person. I was arguing in one matter. Millard, Justice Sen said, don't take it on you because I am against you. Let someone senior argue that.
Therefore, Millard, the principal 2 points on which I'll address my lords is first the 15(4) and the consequences which the learned single judge ought to have taken had he exercised commercial jurisdiction. And the other is, of course, the point of appealability. My submission is that it's a judgment within the meaning of clause 18. So that I will come to later. Millard, section.
No, it is a judgment. There's no doubt about it. But point is, if it is, as Mr. Ghosh says, it's passed in a matter which is a commercial cause.
Yes.
Therefore, section 13, read with order 43.
Yes, it will be a bar. That's his submission. Millard, my submission is that this order has been purported to be passed at least in the non-commercial division, and therefore, in the matter of appealability, the appeal necessarily has to be treated as one in the non-commercial division, and the concept of judgment will apply. Millard, section 15 of the Commercial Courts Act.
Just like the judgment, the doshi. True বসে আছে কেন ওর ম্যাটার তো জাজমেন্ট
আছে Commercial Courts Act আছে
বড় কেউ চাই এটা আর্গুমেন্ট করতে আমি চাই বড় কেউ সিনিয়র লোক এটা আর্গুমেন্ট
একেবারে সুপ্রিম কোর্টে আর্গুমেন্ট করে দাও একবারে শেষ হয়ে যাবে
না এখান থেকে চলে আসছে I'm waiting for that. আমার রিসার্চটা করা আছে আজকাল তো দেখছি যে চিফ জাস্টিস অফ ইন্ডিয়া তার ব্রাদার জাজেস জাজমেন্টের উপর চাইল্ড লুপিট তার মানে জুডিশিয়াল অর্ডারে সুপারিনটেন্ডেন্ট হয়ে যায়। কালকে 3:30 বাজে কালকে ফিক্স করতে বলছি কালকে না নেক্সট ওয়েডনেসডে আমার কালকে তো আমার বাড়ি যাও না উইকেন্ডটা কাটিয়ে হ্যাঁ রোববার আসবো অনেকদিন যাইনি।
Yes. Well, kindly, your lordships have a copy of the commercial code.
Yes, yes.
Section 15. Kindly take section 15. All suits and applications,
Yes.
including applications under the Arbitration and Conciliation Act 1996 relating to a commercial dispute of a specified value pending in a high court where a commercial division has been constituted, shall be transferred to the commercial division. So therefore, any suit which is pending, which is a commercial dispute and pending in a high court, where a commercial division has been constituted, shall be transferred to the commercial division. So this is a case, Millard, which is a pending suit filed in the year 2000, and automatically by virtue of section 15(1) stands transferred to the commercial division. Now, Millard, others are in respect of district courts, etc. Kindly come to subsection 3, where any suit or application, including an application under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of specified value, shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. The provisions of this act shall apply to those procedures that were not complete at the time of transfer. The commercial division, that's subsection 4, or commercial court, as the case may be, may hold case management hearings in respect of such transferred suit. This provision is important. May hold case management hearings in respect of such transferred suit or application in order to prescribe new timelines or issue such further directions as may be necessary for a speedy and efficacious disposal of such suit or application in accordance with order Capital Roman 15A of the Code of Civil Procedures 1908.
Against the
Then
objector.
the proviso is very important. Provided that the proviso to sub-rule 1 of Rule 1 of Order 5 of the Code of Civil Procedure 1908 shall not apply to such transferred suit or application, and the court may in its discretion prescribe a new time period within which the written statement must be filed.
Rule 1.
This, Miller, proviso or this subsection, including the proviso, have been considered and pronounced upon by a number of high courts. I shall come to those judgments. But the basic provision is that sub-rule 1 of Rule 1 of Order 4 of CPC does not apply, and the court may in its discretion prescribe a new time period within which the written statement must be filed. This applies for transferred suits.
Interpretation. We had suggested that the parties resort to formal mediation for resolution of the disputes between them. Stop. Paragraph. Mr. Chatterjee, learned senior counsel representing the appellant oblique defendant, says that his client is agreeable to try out mediation. Stop. Paragraph. Mr. Ghosh, learned senior counsel representing the respondent oblique plaintiff, says that his client is not agreeable to go to mediation. Paragraph. In view of the above, we have taken up the appeal for hearing. Stop. We have Mr. Chatterjee, comma, learned senior counsel, comma, begins his argument but does not conclude. Paragraph, এটা commercial and non-commercial.
It's a filed in the non-commercial division.
তার আগে, হ্যাঁ?
It's filed in the non-commercial.
Yes, yes, it is in the non-commercial.
Filed in non-commercial.
The suit is
List the matter once again. না, তুমি সোমবার রেখে দাও না লিস্টে। On Monday. It will be the list, unlikely, retaining its position.
Yes.
Retaining its position.
Would it be a lordship's pleasure to consider this because Mr. Dutt has to come from Delhi? Can it be Wednesday so that the chances of taking up are higher?
Very well. No. Monday doesn't mean Wednesday it will not be there.
No, only thing is that he has to wait. But however, he will.
Oh, no. Don't. Then Wednesday. Wednesday করে দাও।
My junior says he is not there.
Oh, I see.
তবে তো একটা অন্য দিন।
Then let
আমি আছি সবসময়।
Wednesday? What's? No, but Mr. Chatterjee will argue for some time now, Mr. Ghosh.
I'll take some.
Wednesday, sir.
That's all.
Sure.
Would it be a lordship's pleasure to keep it at 11, 12:30 or something?
We are not giving. It will be
It
fairly at the top. এই উপরে যেন থাকে, যেন ডাক হয়, হ্যাঁ?
Review application.
It will be up on the server. You can see.
Grateful.
I'm not reading the entirety of it. Grateful. Dealt with the submissions of the parties. Detailed order.
Lordship, before rising, my lord, may I be permitted to mention one matter ready for hearing? If your lordship kindly include in your lordship list, my lord. One ready for hearing. One matter, my lord. Kindly, my lord.
You can give it. I don't know when I'll be able to take it.
Well, my lord, will kindly let it appear. Grateful.
Thank you.
My lord,
Great
last
honor.
occasion,
Item number 11. I can continue for 1 hour because others are also eating. I continue after 3 p.m.
3 p.m. This will continue at least till 3 p.m.
Many people came and asked me, listen, you will get your chance. Well, before the election recess, I wanted to show you Lordship a chart. This is in volume 1, page 119. Kindly take note what was the call, and this was at the instant, the invitation of the tribunal. Both parties submitted. Both parties. Kindly see, my lord. In the first year, I was to give them up to 5th May. Total amount I gave them 973,326. My obligation was to give them 0.75 million, that is 753,000. Way above, I gave them first year business. I went up to 5th May 2008 because the contract was from 5th May. This was for 2008-9. Kindly now take for the whole year up to 2009. Total quantity I gave them 2009 and 10, 191,952. That means 1.91 million tons. Expected to go beyond 2 million. And there is no whisper in the, so far the majority out tribunal, the award is concerned. 1.91 million tons. Yeah, thank you. Third year, 2010-11, it is 2.08 million tons, above 2 million tons. In the fourth year, that is 2011-12, it is 1.86 million tons. Way above 1.5 million tons. If your lordship takes that yes, 1.5 million tons and 2 million tons, the median should be 1.75. Even then I'm crossing. So it's expected to go beyond 2 million tons. The arbitrator, the majority did not consider this document at all. A very important and relevant document. And which is the ground under the so far ONGC and associated builders that this is a relevant document not taken into consideration is a ground for setting aside. Unfortunately, the appellant also did not allude to this document in the course of their argument. Doctor, the whole everybody expert with you. Yes. Now,
Mr. Mitro, Mr. Ghosh will keep us occupied till 3 o'clock, he says.
Yes.
Your matter is fixed at 3:30.
Yeah.
Oh,
I just came to tell your lordship this. I didn't want to interrupt my learned friend. At 3 o'clock, my lord, a matter of a part. I did not know this matter will be fixed at 3:30 today. But I have got a part-head matter before at 3 o'clock before another learned judge. So most probably I will be, by the time this matter is called on, I will be engaged in that. So I was just wondering, and unfortunately, my lord, my learned junior in this matter, Mr. Choin Gupta, he has gone to Bombay with his father. He was this,
At 1 o'clock.
he is here.
Today he did the matter at 1 o'clock.
Go to Bombay because Sir Gupta looking Gupta is having a very big problem, medical problem.
I see.
Tata Cancer Research.
Look here. Look here.
So I was told that Mr. Chan Gupta will not be coming to court because he is more ready than I am.
No, that is all very well. We have no problem. Please try to spread the word. Try to spread the word because otherwise nobody will come.
Exactly, that's the point. That is why I thought that perhaps I should mention, tell your lordship, otherwise, because it's my due. I never miss, my lord, a matter which is in court.
No, this was fixed. This was fixed on the last occasion only.
I didn't remember that it was fixed at 3:30. Well, may I do this? Let me see if I can get that matter adjourned and come.
That will be very good if you can.
But when you stand,
But if I am not here, then my lord, I will be feeling very embarrassed. Okay.
it's more than Ashish is telling you.
Arbitration has taken a decision at 3:30, right? Courts will rise at 3:30.
আজকে না কালকে জানো না কিচ্ছু একদিন আগে 24 ঘন্টা আগে করে ছুটি নেন
Before you go.
কালকে তো হতেই হতো
So before my learned friend disappears, because after that, for the first time I'm meeting him, that when will he stand his lunch or dinner? He promised us. Because he was saying India will lose, I'm going home.
Yes,
And he said, I will give you lunch or dinner if India wins.
Yes, I have promised that. I have promised that.
And since then he has disappeared. He has disappeared.
When the match started, I said, definitely India will lose. And I'm not going to see this. And so I left.
He left.
And then my lord, he rang me up and he said, now you stand it. And I said, why? He said, India has won. Unbelievable. So I have promised him.
No, but now that you have shared this with us, you have to share that with us also.
Your lordship, please.
Yes.
Very well.
I'll try and come back.
PSPA sale regional competition.
Yes.
21. 21 থেকে শুরু হচ্ছে 22.
Your lordship will kindly take page 121. The comparison of the two. There's not much difference between the two. Actually, the computation is for the year-wise. They took financial year, we took agreement-wise. But forget about the first year, I gave them 900 for more than 0.75. 973,000. Balance 3 years below, total amount they handled was 5.85 million tons. Divided by 3, it will come to 1.95 million tons each year. So it was expected to go beyond 2 million tons. First part of 5.12 does not come in play. This was my argument. Even in the court below. Completely misdirected themselves, non-application of mind. And also forgetting about a very vital document which will throw a light for the adjudication of the dispute between the parties. So your Lordship will kindly make a note of page 119, 121, and 122. At 122, if your Lordship takes, according to sale, total for all the years taken together was 6.8 or 83 million tons in the middle of the page, my lord. And according to VSP, it's even more, 6.84 million tons. So VSP is showing positive by 3095 thousand tons or whatever it is.
Then.
No, it is, yes. That's why they were below, although according to them, to the appellant, we were not giving them notice, we are not doing this. They could have terminated the agreement. No, because sale was a valuable customer. That was what Mr. Ghoshal said before TAMP, they said. Rashtriya Ispat Nigam Limited had went off to Gangavaram Port. Sale was the only one they left. And they were giving, they had to. Now, another point, আমাদের পরে years, subsequent years, কিছু দেখালো, no demurrage or subsequent years. Review page 100, page 80, page 100. Now, this document is shown by the appellant. No, I said page 100, that page. Yes. My lord will kindly come to follow.
Volume 1, page 100.
Volume 1, page 100. This letter from respondent to the appellant. We are pleased to issue this work order to you. Volume 1, page 100.
100.
Yes.
Yes.
We are pleased to issue this work order to you for handling our coking coal vessels at your terminal for a period of 6 months, extendable by a further period of 3 months at sales option. Kindly see the rate. Rate has been reduced. Consolidated rate is now 166.50, including documentation up to wagon loading. No escalation shall be payable by sale during this period. No escalation. It's clear. The committed discharge rate is there. Berthing priority. Kindly come to para 3 or clause 3 on the next page. Storage space. VSPL shall provide dedicated storage space for 175,000 metric ton for storage, up to 5 grades of cargo to sale, irrespective of any time limit. So no VPT, 90 days, 120 days, they've all disappeared. Whatever they have argued, this letter was relied upon by Mr. Ghoshal read out the first page. He didn't read out the para 3. পরেগুলো দেখো তো কোথায় এসে ওখানে ছিল আরো আছে। Similarly, my lord, if your lordship be kind enough to come to, I think same page, another one he showed 20th September 2014. কোথায় আছে এটা দেখো? He said page volume 1, page 100. This is a letter from Sale to Vizag Seaport.
100 is the work order.
Yes. Then the further work orders.
Page?
Well, like Mr. Ghoshal said page 100. I don't know. That was the 20th September 2014. তোমরা বলেছিলে হ্যাঁ তোমরা বললে 100 আমি ওটা পড়ে দিয়েছি 7/9/2014 পেয়েছো
Page 130.
page 130 হ্যাঁ 20th September 2014. My lord, yes. We are pleased to issue this work order to you for handling our coking coal vessels at your terminal for the period up to 31/3/2015 with effect from 29/2014. This work order is extendable or not period. Rate. The consolidated rate payable by VSPL to VSPL will be 189.90 for the entire operation during the documentation up to wagon loading. No escalation shall be payable by sale during the period of contract. Then committed discharge rate, berthing rate. Now, Miller, kindly come to clause 3 on the
VSPL. Whether it contemplated payment of damage. ইনি বলছেন একেবারে আমাকে whisper consolidated rate of 167 per metric ton. দ্বিতীয়, even if it does, if it imports the provisions of Major Port Trust Act, if VSPL is able to maintain, we have stepped into the shoes of VPT. If actually VSPL has not paid or has not been required to pay demurrage to VPT, get asked actually have you paid? What's this question? Yes, Mr. Ghosh.
Yes, kindly come to clause 3. PSPL shall provide dedicated pre-storage space for 175,000 metric tons for storage up to 5 grades of cargo to sail irrespective of any time limit. Was there any dearth of Mr. Ghoshal was saying didn't have any storage space. I required to pay demurrage. No demurrage, irrespective of any time limit. Then, in the event sale requiring additional space, VSPL shall provide additional space to store cargo free of cost to sail over and above 175,000 metric tons, irrespective of time period. We're a very valuable customer. We're importing millions of tons every year. You get a huge amount. And kindly take below the last page of that letter. Received and accepted VSPL. No dispute. Now, although these documents were before the tribunal, not a whisper in the majority award. I'll say this is not an application of mind.
No, these work orders were not considered. No reference at all.
No reference. I'll come. I told you I shall come to the majority award, minority award. I'll show you, Lordship. When VSPL was really jumping that, you have to give me demurrage. I said, why didn't you ask demurrage here? Irrespective of any time, I can keep it not 120 days, 6 months, whatever it is, because they were getting huge amount of money. Huge amount they have made. One thing, they are paying license fee only once a year. But every time the cargo, there was coming and going, it was steady flow. We had to pay the lease, whatever flows within bracket, inverted commas, lease rental. Think of the lease rental they've taken from the appellant, from respondent. Crores. They have made huge amount even by way of lease rental. But I'll show you, Lordship, so far the minority award. That's why I said, Lordship, I'll go to the majority, minority, then I'll show you, Lordship, the judgments. Judgment, if the judgment is a trial court, why the learned judge accepted the minority award? There was a certain protest that minority award cannot be, but we showed that below to one Supreme Court judgment, Judge Russell, Gary Bang, all. Minority can be. It gives throws a vital light on the disputes between the parties. It should not be thrown in the waste paper basket. Even the Shemingsi, the minority award was accepted by Mr. Justice Nariman. Without award.
470.
No, I cannot say I was at the following position. The following position, what is awarded at the following. Only award. Volume 4.
Volume 4, 470.
Volume 4, 478, continued 4. Page 478. This volume only consists of the two awards.
Volume 4, 478. This is what majority?
Both the awards are here.
One after the other.
One after the other. Justice Mehra was whose nominee?
Our nominee.
Justice Surya Rao was their nominee.
And this is Narayan Seal. Justice Narayan Seal was the
Majority award was of Justice Sill and
to
Luriara Narayan.
The first, my lord, we made an application. No. Under section 60, you'll find in page 2 of that volume. The respondent. So what is it called? Volume 4. বলো কোথায় আছে page 2 টা? তো 479 দেখো। No, it should be page 478, 479 or 4, internal page 5. 480. Respondent extent of filing statement of defense. File application under section 16(2), questioning the jurisdiction of the tribunal. The claimant filed this counter, everything. Then it was ultimately held that it is a private contract. And therefore they had jurisdiction. So I'll not trouble your lordship much with this. There's nothing turns on this. They held that so far TAMP will not apply. This is a private contract. This is a private contract. Kindly come to issue number 1 at page 17, paragraph 41. At the time of deciding the application of the respondent under section 16(2) of the Arbitration and Conciliation Act, it was decided that since the claim of VSPL is based on breach of contract, as mentioned in the original page 491, paragraph 41 of the award.
Yes.
At the time of deciding the application of the respondent under section 16(2) of the Arbitration and Conciliation Act 1996, it was decided that since the claim of VSPL is based on breach of contract, as mentioned in the original petition before the tribunal, the question of breach cannot be decided by TAMP authority, and accordingly it was held by this tribunal that the claim petition is maintainable and the application under section 16 of the Act was rejected. This is a bit of private contract. That was clear, the understanding. Now kindly come to Milord, how they've interpreted 5.12. That is on the following page, paragraph 46. they have set out clause 5.12. I've already placed it before your lordship. If it is for 60 plus 30, that for 90,000, it will not be go down more than 15 continuous days. The question is, if it is 60,000, there is no limited period. With 30,000 more, then comes 15 days. So 60,000, it can be kept as long as you like. Similarly, if it is expected to go beyond 2 million, expected to go beyond 2 million, VSPL shall organize a storage of cargo up to 90,000 with a further provision for 30,000 for a period not exceeding 15 days. VSPL shall stack the cargo in an orderly manner. This I showed to the tribunal. Look at the subsequent work orders. Unlimited period. In fact, in one case, 167, it came down to 162. But I have to give them 175,000 metric tons, which I was willing to give. Yeah, it's already shown your lordship. There's always in 3 years, it was 1.95 million tons. Kindly come to the following page, internal page 19, para 52. On a plain reading of clause 5.12, as quoted by us above, it will be clear that the same consists of two distinct parts, which is admitted by all. And in two parts, the provision for free period is 15 days has been separately mentioned. And in case of the first part, it specifically mentioned provision for 30 days notice. First part of clause 5.12 of the STA again consists of 3 sentences. The sentence says VSPL is obliged to store up to maximum cargo of 60,000 metric tons. The second sentence starts VSPL is obliged to accommodate cargo of further 30,000 metric tons in a case of exigency for a period not exceeding 15 continuous days. The third sentence starts with the word however, and makes sale obliged to give 30 days notice for such higher volume of cargo. Then, look, kindly come to para 55. It is a pointer to know the second part of clause 5.12 of STA. There is no whisper of notice, although the free period of is 15 days, because the first part, the day-to-day clearance of cargo, keeping the cardinal principle of MPT Act that the port area is not to be used as warehouse. The MPT Act, where does it come? This is a private contract. They have got a license for 40,000 square meters dedicated to sale. The second part of the clause deals with cargo volume on per year cargo commitment basis when VSPL would keep itself ready to accommodate 90,000 per 30,000 metric ton in case of exigency for the period not exceeding 15 days. And this is when cargo commitment by sale to VSPL is expected to go beyond 2 million metric tons. In this case, VSPL claimed demurrage storage charges on the basis of first part of clause 5.12 of STA. In view of all above, our mind leans to accept the interpretation of the clause that when the amount of cargo exceeds 60,000 continuously for 15 days without any 30 days notice, VSPL is entitled to claim demurrage stokes. Completely ignores the vital document. Completely ignores, which throws so much light on the disputes between the parties. Then kindly come to para 63. Furthermore, the respondent itself tried to build up the case on the notification of TAMP authority. It was argued before us that in terms of item number 22, C109, the term transit area was deleted at the request of the claimant. When they produced it, I pointed out, look, at their request, transit area has been deleted. I am not relying upon TAMP. They produced it. Kindly come to para 71. It was also argued right at the bottom, my lord, at page 24. Award page 24. It was also argued on behalf of the respondent that the claimant, while dealing with TAMP authority, deleted the term transit area in respect of user of port area by sale. It is also argued in this connection that the term demurrage was also deleted while dealing with TAMP authority at the instance of VSPL. Then, let us see these matters appear at page 108 and 109 of TAMP notification of 2005. On perusal of the clause, so on and so forth, demurrage was deleted. Rather, the TAMP authority observed that the private operator himself desired to offer competitive rate. There is no justification to increase the proposed rate as suggested by VPT. Private operator. He is private, he is operating, he wants to maximize his profit to get the money he has invested for building. On perusal of clause, it appears that the term transit area has been defined as the area to be notified by the BSPL from time to time when demurrage becomes payable on expiry of free day. It is observed that the BSPL has not modified the definition to explicitly specify transit area. It is observed notification about the area to be considered as transit area is an administrative matter to be decided by the operator, and in the absence of any specific definition of this term, it is not found necessary to include it in the scale of rates, and the same was deleted. It is quoting and unquoting from TAMP. After this, what the argument put forward by the appellant, transit area, demurrage, stacking, it falls to ground. I'm only taking a lot of those places where it is completely contrary to what the appellant has argued. Now, with regard to diversion of vessels, I pointed out that to the tribunal that, look, they are asking, SAIL was diverting its vessels to Gangavaram port because they are charging demurrage and they say we are full. They were full at that time and they were charging demurrage. We tried to divert it. To that, BSPL objected. Those letters are there. Kindly take para 72. This should. It further argued on behalf of the respondent that the behavior and dealing of the claimant is self-contradictory. The claimant all along insisted on more cargo and ships in the port area. At the same time, the claimant went on charging demurrage. Why should I pay demurrage if you're going to charge me when you're full? In this connection, learned senior advocate so-and-so has referred to page 177 of SOD, item number 110, at page 279 of C series, page so-and-so. It was pointed out by him from page 177 of SOD that one hand the claimant resisted diversion of vessels, and on the other hand they charged demurrage, page 1212. Similarly, he has also referred to page 179 of SOD, which I refer to all the on record those jobs. Then, kindly come to the last 3 lines of that page. It appears from the letter of the claimant at page 283, in respect of diversion of vessels to Gangavaram port, the claimant wanted to place it on record that diversion of vessel was in deviation of clauses 1.2a, 4.1, 4.5, and 4.8 of STA. In other 2 letters, the claimant apprehended causing of huge loss for the diversion of other vessels of sale. Clause 1.2a of STA speaks about assurance of 1.5 million metric tons per annum to VSPL berth for a period of 3 years from the signing of the agreement, or extended period, if any. Other claims as mentioned in the letter also deals with the volume of extended cargo. This is the portion I'm really assailing. It is the universal practice of business. Nobody has proved the practice, and the arbitration tribunal was not maritime experts. The universal practice of business is the parties involved in such commercial transactions will always look forward to more and more profit. And in doing so, if there appears any violation of the agreement inviting penalty or demurrage, the same cannot be avoided as denied. Cannot be avoided or denied. Kindly read, it is universal practice of business that the parties involved in such commercial transaction will always look forward to more and more profit. And in doing so, if there's any violation of the agreement, tribunal is saying that you violate the agreement to make profit. It's so absurd. It should shock the conscience of the court. Inviting penalty stroke demurrage, the same cannot be avoided or denied. Universal practice, they are not. Who has proved the universal practice? Without any evidence, and it's something which should shock the conscience of the court.
But isn't it the practice that every party involved in a commercial transaction would want to make more and more profit?
Not as a risk of making breach of the contract. Not as risk of making breach of contract. You certainly, but where is the universal practice so far the maritime law is concerned? There is an agreement in writing. Within the 4 corners of the agreement, the tribunal has to proceed. Tribunal can't import something which is totally not within the contemplation, or not within, and not by saying, even if it involves breach of contract. Take, for example, my lord, your lordship, since it fell from a lordship, some materials are inflammable. Also, coke is coming, coking coal. So supposing it's inflammable, the whole place will go up in flames. You can't go on stacking. But What I wanted to show your lordship that I'm just to answer your lordship, but that is not the point. Point is the universal practice and if it involves breaking the law. Now, up till now, your lordship has not seen any reference to the chart or any reference to the other subsequent work orders. Now, next is a review meeting. It was also argued on behalf of the respondent that in the review meeting, as provided in clause 8 of STA, the claimant never raised any question of payment of demurrage. On the other hand, the claimant accorded incentives to the respondent by lowering the rate from 167 metric tons as mentioned in the ITSC. It is also argued on behalf of the respondent that such incentives, rebates were given by the claimant to SAIL because SAIL was the biggest customer of the claimant. This is not denied by the advocate of the claimant. Learned advocate for the claimant has drawn our attention to the provision of clause 8 of STA and tried to impress us the purpose of review was only to assess the actual quantity of cargo that can be made available to VSPL terminal to test the operational parameters, after which the terms will be reviewed jointly and if required, terms and conditions will be further revised. Learned advocate for the claimant further argued that sitting in the review meeting had not exonerated the parties of payment of contractual dues, which is again supported by statutory dues fortified by time order. To our mind, the stand of the claimant in this regard appears to be acceptable. Question was whether why didn't bring up question of demurrage and terms could be revised. That's been written there. They could have revised the terms. And this was in October 2009. It should have been held in November 2008. The review meeting took place after 1.5 years. And still, my lord, and the tribunal, again, I should say, my lord, this is something which is not a question of interpreting a clause in the contract. Yes, interpreting a clause in the contract, it is within the tribunal's jurisdiction. But if it's something which is so absurd and which is nothing to do with the clause 8 at all, then it should shock the conscience of the court. Now, kindly come to, my lord, para 81. I'll only take your lordship to the majority award. On the point of 30 days notice, it is pertinent to note under clause 14.5, it reads as under amendments and waiver. No amendment or waiver of this agreement. I am not asking for waiver. I said by their conduct they waived, assuming without admitting. They could charge demurrage. By their conduct they waived. That was my argument. It shall be binding unless executed in writing by the parties to be bound thereby. I am not asking for waiver of the agreement. That was not my argument. No waiver of any provision of this agreement. No waiver of any provision of this agreement shall be deemed to constitute a waiver of any other provision. That's not. I am only on 5.12 demurrage. Assuming without admitting the demurrage is not payable, even then, by the conduct they waived. They consciously gave up a known legal right. Then he said, a perusal of the above accepted provision showed that no waiver of the agreement is binding with the parties unless given in writing. I have not asked for that. No provision shall be deemed to have been waived continuously. I didn't say that. In view of the above provision, the respondent cannot validly plead any waiver on the point of 30 days notice. We have the considered view that the principle of waiver is not applicable. Now, my lord, my learned friend also relied on this page 31, paragraph 99. Stamps order dated 2nd April 2007. The actual area leased by VPT and the reason for variations, if any, from the lease agreement. The answer was lease area for backup as per LA, that is long-term agreement, is 90,000 square meters. However, further land was allotted to it by VPT. The present area leased is to the tune of 121,700 square meters, and lease rental must be paid for the said area as per rates prescribed by VPT. That is between VPT and VSPL. Since major portion of the storage area will be used on rental basis, income from plot rental has been taken into account. It does not desire or expect cargo to remain in the transit area beyond free period, and hence demurrage income is considered nil.
Sorry, Mr. Ghosh, yes.
Yes. Kindly come to para 99. This is stamps notification, paragraph 6.1.
Yes, that table, table.
Yes, the table. Lease area for backup as per law LA is that long-term agreement was 90,000 square meters. Now it is so it was 90,000. They themselves admitted before TAM. So that has been overtaken by STA, where it is 40,000 now. However, further land was allotted to it by VPT. The present area leased is to the tune of 121,700 square meters, and lease rental is being paid for the said area as per the rates prescribed by VPT. The reason for not estimating income from demurrage charge, it was a query of TAMP. Since major portion of the storage area will be used on rental basis, income from plot rental has been taken into account. And it does not desire expect cargo to remain in transit area beyond the free period, and hence the demurrage income is considered nil. Admitted position with some of these things. I do not wish to do it. All is very prolix. Award? Huh? তিনটে পেজ আসু ঢুকে এসেছে Now, my lord. It will take big. Can I continue on the next day, my lord? If the others are here.
Mr. Gupta, will the Jesop matter be taken up? Is Mr. Mitro coming? Mr. Mitro told us you are in Bombay.
Yesterday. I came back today.
You came back today. So Mr. Mitro will come at 3:30. Find out, yes.
I'll continue that. Then take page 114. You compare 114. Whether it is a case of damages for breach of contract or demurrage for exceeding free period or storage charges, for us, same reason it is in sequence to the infraction of clause 5.12. The claim of damages depends upon the proof of loss suffered and the quantification thereof commensurate with the loss suffered on account of breach, unlike the latter two categories. It admits of no further proof of damage, leaving regard to the situation obtaining in the instant case. It is indubitably emerges from the matrix that the respondent allowed the excess stock of cargo remain beyond free period. The consequential loss is obviously the demurrage of storage charges to which the claimant is entitled to in terms of TAMP notification. The rates fixed by TAMP towards demurrage of storage charges, as the case may be, can conveniently be adopted in quantifying the damages. Where does it get the TAMP? The claimant is not entitled even a pi more or pi less for the storage charges fixed by TAMP, save and except the concession rate to be given, if any.
Now informed that he is on legs in a matter which is almost on the verge of conclusion and he is coming.
In any view of the matter, the entitlement of the claimant for demurrage or storage charges cannot be doubted, having regard to the discussion herein above. 115. Now, having plunged into complex and tortuous methods of calculation in order to quantify the claim of VSPL, in order to arrive at a correct decision, we will be alert to the conditions of 5.12, which has been discussed earlier. Therefore, the entitlement of VSPL will be vitiated if in any day of a fortnight the stock falls below short of 60,000 metric tons. Is still on the first part. He is not applying his mind to the second part applies. The vital document. First part does not apply. That was the respondent's contention. Then again, the date fixed for clarification on some points from the parties as on their arguments and documents. The learned advocate for the claimant submitted legible copy of the dates on which the cargo of sale was above 60,000 metric tons, along with date, limit, actual stock excess rate, storage charges from the list. Then he below 160. All that I can say, below, I pointed out this was not for 15 continuous days. I showed them even the chart, revised chart the claimant was giving. 3 times they gave. Every chart had some infirmity. Then comes thus, and every time the tribunal entertained those charts and discarded them. Thus, again, with the change of position of the fortnights for non-continuity of excess cargo in terms of condition of clause 5.12 of STA, as discussed by above, the rates are also supposed to be changed in terms of TAMP orders. This is an agreement. You can't travel beyond the 4 corners of the agreement. Section 28.3, this is actually illegally, totally illegal on the face of the word. Patent illegality. Accordingly, certain amounts is liable to be deducted from the total claim of VSPL. B as a calculation in this, but as a calculation in this regard is very complicated, we'd like to deduct a lump sum. This is the learned tribunal is entering in the field of our conflict. They are supposed to adjudicate whatever is there. They are not to calculate on behalf of the claimant. Say 40,000, 19 crores, so and so, interest. The award is for 19 crores, 68 lakhs. Lord Denning once said that, blinded by the dust of judicial controversies, the learned arbitrator himself entered the arena of conflict. This is a classic case. He himself entered the arena of conflict. They started calculating. And then, like a blue pencil, 40 lakhs deducted. Majority cannot stand the test of whatever the test laid down by Supreme Court. I'll come back with the minority award member next day. That will take quite some time. So your lordship is fixing next Wednesday. এবার তোকে স্টার্ট করতে বলো এটা বসে এতক্ষণ ধরে যে আপনার কতক্ষণ চলবে বলো কাউকে স্টার্ট করতে
লিখে না এটা কি অরিজিনাল সাইট Mr. Ghosh from a learned senior counsel representing the respondent begins his argument today but does not conclude. Paragraph lists the matter once again on Tariq Budbar, retaining its position.
Grateful to your lordship. Budbar.
পরের দিন
বসে যাই জানো একটু বসে যাই
But I'm for the official liquidation.
It is that matter, my lord, where surveyor, my lord, as per your lordship's order, surveyor visited the places, my lord, and he has settled that where the property can be given to them, the appellants. Lord, that is also in respect of your last report also, it was mentioned.
Only point is to be decided, which is 2014.
Yes.
We think, Taina. You were out of, you paid the money in 2014.
You paid money before that. 2014 recognized the payment by Justice Patharia's order, which recognized my payment. Paid prior to that, 2011, 12.
Have you seen the survey's report?
Yes, we are agreeable. We have demarcated.
Agreeable. Well, let's finish it off.
Yes, virtually we have demarcated, but physical demarcation has to be there.
Yes, my lord, physical demarcation has to be there because excess land is required to be sold by the official
Yeah,
liquidator.
of course. So what should we should adjourn this or keep this pending?
But
We should I mean, dispose of this application.
That date, Lordship will indicate. 14,
Yes, yes.
And will direct the parties to go for a physical demarcation.
Where's the you have applied, na, made an application.
We filed an application.
That is number of the application is?
That is the first GA.
There is no GA, ACO.
ACO 2. CA number 12 was the application before the court bill. Rajesh Saman is, when Lordship takes the paper book, Rajesh Saman is there. Pairs of content there. Volume 1 এর প্রথমটা ছিল
Volume 1.
Volume 1 has the prayer which I made before the court, Honorable Single Judge. Volume 2 has the stay application before this court, where I have also made the same prayer for handing over of position of the 2014 calculation. That's volume 2, page 276, 275 are the prayers.
Volume 1, page?
Page 1, that is the application which I filed before the court below, and prayers that you could find at page.
So this money was paid to the company as what?
As the company was in liquidation, dues of bank, I paid off to the bank directly on behalf of the company.
But the company did not come out of liquidation.
Page 4, volume 1, page 4.
You were what? You were contributories?
I was one of the contributors.
One of the contributors. You were Bhasdeep Infrastructure?
Yes.
When did the company go into liquidation?
But, 2006 was the application filed, and thereafter there was a settlement which failed, and subsequently
20th June, 1984. Binding of order was passed, my lord. That was mentioned in the last report filed by the official liquidator.
Why did you, judges summons pray for 9 crore?
Because we are calculating
interest
in case we get the refund.
Interest.
That is most of 60% of his interest. 4 crore and the rest is interest.
Where's the order of binding up?
No, my lord, that is in the report itself. It is mentioned. The official liquidator's report, first page, page number 4. Paragraph 1, that pursuant to the Honorable High Court's order dated 20th June 1984, passed by
কোথায় ওয়েলের রিপোর্ট কোথায় তুমি ফোন দেখলে কি করে চলবে বলছেন না ওয়েলের রিপোর্ট
last din file
last
সার্ভিয়ারের রিপোর্ট
extra copy থাকলে report dated 25th Right.
Yes, yes.
25th April 2020.
In pursuance of your lordship's order dated 25th July 2025, my lord, this report was submitted.
And where's the, you filed an appeal, na?
That I filed an application for the honorable single judge in the company proceeding.
Where's the order passed by the single judge?
So that was the volume, that's in the volume 2, Milord. Yes. Page number 2. The order dated 12th June 2023 at page 230. You will get a better copy at page 3. Better copy at 253. But order portion starts from page 232. This is the impure order in the appeal. Is reading the impure order. This is the report. But I mean, later, Mr. Good.
12 June 23, this is the impugned order.
This is the এটা তো এটা এগুলো ই করছে আমি এমপি করছি এটা করছি ব্যবসায় করছি
What does the learned judge record that by orders dated 14 May, 4th April, coordinate bench had granted relief to you?
Yes, yes, that is the prior order.
Then order dated 4th April 2019 was vacated.
Yes. First order of Justice Patheria, then Honorable Justice Patheria, then Justice Honorable Justice Sinha confirmed that order and said no need of clarification, you proceed. That order of Justice Honorable Justice Sinha was vacated by this order, by another order, which we asked recalling of it. That was the application before the Honorable Single Judge where he dismissed my application.
So where is that order? 4th April?
4th April order. That's pretty much. Same volume. 4th April.
এইখানে আছে পরের পর
Page 160.
No.
Sorry,
166 ঠিক আছে আমি বলে volume 2 page 166 is the order impugned. No, order impugned. Page 232 is the order impugned. Lordship, my learned friend is correct, Millard. 22nd November. Also, Millard, Lordship will take Millard the order of Millard. Order at page 228 also. Lordship will read first. This is the order of 22nd November 2022, by which the order of the coordinate bench, which is at page 166, was recalled.
এখনো 4th April orderটা খুঁজে পেলাম না page.
4th April order is at page 166. 166, Millard, volume Millard 2, page 166. 4th April got vacated at page 228 by an order of 22nd November 2022. In my absence. And I went forward to ask for recalling, which was Millard not considered Millard. That's page number 232. That's the order under appeal. 8 to pata. 3. Lordship has to see 4 orders. Justice Patheria's order, 14th of May 2014, 160. Justice Sinha, 166, 4th April 2019, sorry, 228, and Miller, 232.
Right. Order impugned.
Sure. A company by the name of Bengal Enamel Works Limited went into liquidation when?
1980.
In the year 1984. Stop.
20th June 1984.
The present appellant was one of the contributories. of the company. Stop. The dues of the United Bank of India were to the tune of rupees 450 lakh. Stop. Now, the dues of the United Bank of India from the company were in excess of rupees 500 lakh. Stop. The dues were settled at rupees 450 lakh. Stop. Rupees 225 lakh was paid to the bank by the present appellant on behalf of the company in liquidation. Stop. This was in the year
2006, my lord.
2006. Stop. The balance portion of the settled amount was not paid. Stop. Therefore, the company remained in liquidation. Paragraph. In 2013, the present appellant took out an application before a learned single judge, being CA number 455 of 2013, saying that since it had paid substantial sums of money to the creditors on behalf of the company in liquidation, the assets, the landed assets of the company, which were in the custody of the official liquidator, should be released in favor of the appellant herein. Stop. An order dated May 14, 2014 was passed by the learned single judge, the relevant portion whereof reads as follows. Page 163 থেকে, bracket করে দিলাম 163 থেকে 165. Next order. Next order.
Next order, my lord, is Justice Sinha's order, which is at page 166 of your lordship's brief.
Next.
This was on the application of the official liquidator.
In the year 2017, the official liquidator filed an application before the learned company judge,
Yes, lordship.
being CA 458 of 2017, praying for directions. Praying for that.
That's page 179, the direction.
Page
179, the prayers, lordship. For lordship's convenience, I have said. B, C, and E has prayed.
Praying inter alia for the following orders. করে page 180 থেকে B, C, D, rather A, B, C, D করে দাও. A, B, C, 179, prayer A, 180 তে prayer B, prayer C, set up, huh? এক কাজ করো, একবারে DE পুরোটাই করে দাও. E. Paragraph. The said application was disposed of by the learned judge by an order dated April 4, 2019, by passing an order in terms of prayers B, C, and E of the official liquidator's application. Then,
my lord,
this gets recalled.
My lord, this gets recalled in, my lord, by an order which lordship will find at page 228. I was not there. This was not served in someone else's application, my lord. Gets recalled.
Next. It appears that on an application, you do not know who made this application.
Family member of the company.
This application was made by the family members who were promoters who had the rights in the leasehold land, Millard. So that was, Millard, in nature of this Tara Shankar Ganguly.
On an application made by one Tarashankar
Ganguly.
Ganguly, being IA number CA 9 of 2019,
I'm sorry, Millard, it's Bhavani Shankar, Tara Shankar, Bhavani
Shankar Ganguly,
Bhavani Shankar.
a learned single judge, by an order dated November 22, 2022, recalled the earlier order dated April 4, 2019.
Yes, Lordship.
Stop. This order was passed without notice to the present appellant. Next.
Millard 232, where I had filed for recalling, Millard. So that was not entertained, Millard, and this was also dismissed, Millard, as infructuous. 232 at 233.
Paragraph. The present appellant filed an application being IA number CA 12 of 2023 for recall of the order dated November 22, 2022, whereby the earlier order of April 4, 2017, April 4, 2019,
2019
had been recalled. Stop. The said application was dismissed. This is the impugned order, 12 June.
Yes.
Was dismissed.
As infructuous.
Impugning was dismissed by an order dated June 12, 2023, which is impugned in the present appeal. Paragraph. We do not see why the order dated May 14, 2017,
May 14, 2014.
2014 should not be given effect to. Stop. It is not in dispute that way back in 2006, the appellant company paid rupees 2.25 crore to the creditor bank, thereby liquidating part of the company's debts, part of the debts of the company in liquidation, part of the debts of the company in liquidation. Stop. In all fairness, the appellant company should be compensated for that. Paragraph. Earlier, a surveyor's report had been filed in respect of the landed properties of the company in liquidation. Stop. However, we were told that the entire leasehold property of the company in liquidation stands surrendered in favor of the relevant lessors.
Yes,
concerned lessors. Stop. Hence, any property, any portion of the landed property that may be handed over to the appellant as a compensatory measure, must be from the properties which were owned by the company in liquidation. Paragraph A, further surveyor's report was filed in before us, was filed, report dated August 7, 2025 was filed before us on the last occasion, i.e., when was it last date?
Milord.
Last day?
8th August. 8th August.
8th August.
Oh, on August 8th.
আমি কোথায় রেখেছি?
On 8th August. আচ্ছা, রিপোর্টটা হচ্ছে 7th August. August 7 was
আমাকে
filed
দিয়েছিলাম, আমি সেটা মিসপ্লেস
on
করেছি
August 8,
ওনাকে বকিস।
i.e., August 8. Stop. On that day, the official liquidator had also filed a report. Stop. Paragraph, it appears that landed property of the company in liquidation is available from which the appellant may be handed over land. Stop. The question is, comma, when, on what date the valuation of land should be considered? Question mark. Should it be 2014 when the Honorable Learned Judge recognized the appellant's claim, comma, or should it be 2023? Why 23?
Because Milord, that was the day when the appeal was moved and the order was passed, Milord.
This was the order, Milord, dated
That is,
6th
Milord,
February 2024.
That's part of the paper book, Milord.
It has-
Page?
Milord, I have, yes, last occasion I have handed over both the copies.
281 Lordship will take, Milord. 281 of your Lordship's bill. This is part of the paper book. পরে দিয়েছে তো বাবা।
গত সপ্তাহে দিয়েছি, 8 তারিখে দিয়েছিলাম।
281 নয়। I'm sorry, Milord, 287, Milord. 25th September 2023. 25th September 2023, page 287 at 288.
হ্যাঁ, 6th February order ছিল তো, 6th February.
And when this order we got, Milord, we filed an application for clarification, Milord, and there's an order of 6th of February 2024. Copy আর আছে?
Last, or should it be in 20?
দিয়ে দিয়েছি।
ঠিক আছে। And we have filed an application for clarification. ঠিকই বলছি বিশ্বজিৎ।
Question mark. Stop. This question arises since when the appeal was admitted by an order dated September 25, 2023, comma, a coordinate bench had made the following observations. Page 288, paper book. Bracketed.
288 paper book মানে এইটুকু বলছেন।
Next, subsequently, an order dated February 6, 2024 was passed by a coordinate bench, comma.
And we have also filed a clarification application.
On a clarificatory application.
On this order, Milord, pursuant to this order, we have filed a clarification, Milord.
Pursuant to which order?
This 6th September. I was given leave, Milord, to Milord file a clarificatory application, which I have done so before this court. 6th of February, this Milord, 6th February, I have done so.
Order 6th February 2024 was passed by a coordinate bench, comma, the relevant portion whereof reads as follows. 6th February order তোমায় দিচ্ছি আমি, হ্যাঁ, এখান থেকে আবার ব্র্যাকেটেড পোর্শন করে দাও। Paragraph. Pursuant to the leave granted to the appellant, comma, it has filed a clarificatory application, which is listed before us as number.
Milord, I'm giving the number.
Number blank. দিয়ে দিও।
Check করে বলো।
Next. So these are all the orders.
These are all, nothing more.
Having considered the facts and circumstances of the case, we are of the view that the value of land as in 2014 should be considered, the valuation of land. And accordingly, rupees 2.25 crore worth of land should be made over by the official liquidator to the appellant company.
As shown, Millard, as his report. As Millard indicated in his report, Millard.
As indicated in the report of the official liquidator.
Report of the
Millard, the surveyor dated
report of-
25th April 2025.
As indicated in the report of the surveyor dated April 25,
25th April
25th
2025.
April 2020.
2025.
Here, this page.
Stop. Let this be done after requisite demarcation within
Within what
Within
time?
3
Father?
weeks. 3 weeks.
3 weeks.
4 weeks from date.
They should, Millard, they construct the wall.
Yes,
Because
I'll construct the wall, Millard,
the
on my
balance
land.
portion of the freehold land officially will be
Stop.
sent.
The
Next
appellant shall construct necessary wall,
সে 2000 এটা 14
oblique fencing
20
to demarcate
20 or 30.
its property from the rest of the property.
Lord, for the, I don't want any confusion. Page 20 of Millard, the surveyor's report dated 25th of April 2025.
ওই যে surveyor's report dated যে বলেছি না,
Page 20.
April
Page
25.
20 has that
মানে
picture.
page 20 of the surveyor's report. Add করে দাও। Page 20. Paragraph, nothing more.
Nothing. I've given the application number.
Appeal and the connected applications stand disposed of.
Grateful. কি দরকার আমার বলো?
I appear on behalf of the only secured creditor in this matter. So whatever survey reports which have been filed by the official liquidator, may a copy of the same be provided to me order.
Write to them, we are not going to pass any order.
Grateful.
Write to the OL.
আমি
চলো
শুধু
দেখো
freehold land টা পাচ্ছি,
330
আর
তে
কিছু
ডাকো
পাচ্ছি না।
330
One thing, Millard, your lordship, kindly direct the appellant to pay the cost and
Yes,
expenses.
I'll pay the cost and expense.
add করে দাও
I'll call the pay
the
the cost and expense.
costs and expenses
Wall.
relating to
Construction of the
demarcation
boundary.
demarcation
Raising the boundary wall.
of the portion of the land to be made over to the appellant and raising boundary wall oblique fencing shall be borne by the appellant.
Yes, grateful. Much obliged to them. Deeply.
Millard, Mr. Mitra had indicated, Millard,
Eh?
Mr. Mitra had indicated that he would be coming, but he's arguing matter, Millard, is on legs in. But so he said that this is a continuing part and he can't go. Millard, so he's asked.
It's also continuing part.
He's already arguing from 3.
This is also continuing. Well, the only difficulty, Malad, has been, Malad, that
Difficulty is also on this side, Mr. Banerjee, fixing a matter. You know, we have a lot of pressure.
Correct.
Continuing parted matter.
and Malad, this is Malad, we have suffered a stay, Malad, from October 2023, where Malad, the matter
File
has
to
been
the order,
transferred,
file to the.
transferred Malad, to the National Company Law Tribunal. We are the only secured creditor. It was on our application, Malad, which it was transferred. And Malad, the asset is getting depleted. Malad, we are in a position, Malad, neither can we go there, nor can we, Malad, come here. And there's been, Malad, already, Malad, 5 days of arguments. তো তোমরা তুমি বলতে পারো না তোমার তো বলি আমি করে দিচ্ছি তাই তো Well, there are other parties, Malad, they can Malad, start Malad, if they want to, if they have anything to say on this issue.
Mr. Mitra finished because Mr. Mitra is pursuing a particular line.
Do you want to argue, Mr. Gupta? We are happy to hear you. You know that.
But he was almost on the verge of completion, maybe a day. So, Millard,
I don't think
I do not think, Millard, I should
Malad, with
try at this stage, Millard.
respect, Malad, I don't think Malad, this great respect, Malad, and all humility, Malad, that this matter doesn't Malad require Malad
Yes,
so much of Malad.
Not.
And there are Malad, we already have a division bench Malad covering.
You tell us what should we do now?
No, that is Malad. That is my lord.
It's not that Mr. Mitro did not
No, no.
indicate that he may be in difficulty. He came here right after 2 o'clock. He was sitting there. The room was empty. Mr. Pradeep Ghosh was arguing. Mr. Ratnanko Banerjee had also walked in once, I think, then went out
My lord,
again.
I am worried about the other matter, my lord, which I am to, my lord, argue. That's why, my lord, I had
Tomorrow, what do you have to argue?
no, my lord, today only, my lord, my lord, this. My lord, what?
So what, tell us, Mr. Shah, what should we do?
Can you keep it any day next week, my lord?
Take half an hour after Mr. Mitro.
শেষ করে দাও না এখন।
Why don't you utilize the time today, Mr. Shah?
Lord, I can give you lordship the broad propositions, but my lord, I can't conclude. I don't have my lord. Mr. Mitro had said.
Oh, I see.
So, my lord, I'm not. I'll be honest. I'm not carrying the judgments on which I.
No, quite understandable.
Tomorrow, there's no difficulty.
Tomorrow we can't give you time every day.
No. Whenever your lordship sits next, I'll do it. Okay.
At this stage, my lord, I do not wish to, my lord, because he will possibly conclude in 1 day, my lord.
কি ডিভিশন বেঞ্চ আছে দিয়ে দেন না দেখেন না
আচ্ছা তো আমি তো দিয়েছি ডিভিশন বেঞ্চ my lord against this it's already my lord the issue is covered my lord by that division bench and my lord given that
Then, the third part, Lakshadweep Island projects and Annexure 3. In February 2011, BHEL awarded 2 projects to OPS India to supply new equipment and also to upgrade sites at Lakshadweep Islands. These contracts had 2 main parts. A, to refurbish existing old equipment, and also B, to install new OPS equipment. The work was done and completed by OPS India. The same purchase orders include an annual operation and maintenance contract whereby OPS India would be engaged and be responsible for operation and maintenance of different listed islands of Lakshadweep. For everyone's benefit, a local third-party contractor was employed by OPS India who would carry out basic operation and maintenance on the OPS supplied equipment. So, they have employed a subcontractor. Then, the arrangements around operation and maintenance were very difficult, as the invoicing would be accepted on yearly basis, but effectively paid around 90 days after submission of yearly O&M invoice. The contract with the third-party contractor was eventually on quarterly basis, as the contractor would not accept waiting a year and a half for his payment. It was extremely difficult for OPS India to pay the third-party contractor quarterly basis when the payment from BHEL side was yearly basis only, and that also with 3 to 6 months delay in payment. OPS India tried to negotiate with BHEL regarding the O&M contract without any positive result. Later on, OPS India requested BHEL for a quick or immediate payment on the yearly basis and O&M invoices. Somehow, all the efforts were in vain, which resulted in non-payments, penalization, and ultimately stopped work many times at Lakshadweep Islands were quite difficult and costly sites to work and to maintain. Despite efforts in 2014 and 15 to negotiate and renegotiate better arrangement with BHEL, this was not agreed by BHEL, as they became increasingly reluctant to modify any arrangement or even when it would result in a better service to them. With time, it became extremely difficult for a small company like OPS India to continue to support for this O&M and support activities. So, what they did, they left the contract sites, left the O&M work and went away. Now, the negotiated contract was that you will maintain and raise bills, you will be paid yearly. They wanted payment quarterly. They wanted modification of the terms because they say that they were experiencing difficulties. But, you entered into a contract with your eyes wide open. And ultimately, they abandoned the site. Now, these are the admissions. And, here, the summary of claims for Lakshadweep is, they have, raised, they say bills or purchase orders. Kindly see. Total, they say, 17,63,748 parts and renovation of AES PCU. Then, 28,37,620 supply of OPS PCU. Well, there are no details. But they say this is the amount due. Then table 4. Here you'll also find this is hostel project. Please see this table. You'll also find the table which is at this is the page 44. It should be. Yes, page 44. Please see the left-hand column. Name of project: ET Hostel Bangalore, ET Hostel Bangalore. Now please come to the retention invoice numbers and dates. You'll also find a column, retention invoice numbers and dates. This is 1, 2, 3, 4, 5, 6th column. Here you'll also see these are retention amounts which have not been paid. Not original amounts that were required to be paid and were not paid. Now, please see, for example, if your lordship now travels down the column, VR Kanungo Sale Bhilai. If your lordship now comes down to that retention invoice column, invoice number such and such being 15% installation and commissioning costs. Invoice number then again supplementary data such and such being 10% retention of contract fee. Unfortunately, there is no attempt to even produce the contract and to show that under the contract, this is how we perform, this is how we get paid, this is our obligation, and this is beyond the scope of our obligation. The contract is not annexed here. Then we'll find that these are all therefore retention bills, each one of them. And for example, if your lordship will please have a look at again page 45. My lord, your lordship has seen RARA IOCL. My lord, that is the second item at annexure 2 at page 45. Kindly see, my lord, 10% retention. Then your lordship will kindly see, my lord, Raichur. My lord, please see, my lord, against the second item, retention money component 10%. Then, my lord, there's a differential amount of VAT, etc. Now, my lord, and it goes on. Well, at every column, your lordship will find retention 10%, retention 10%, retention 10%, retention 10%. Because, my lord, admittedly, they did not, my lord, complete the work, my lord, to expectations. And, my lord, in one case in Lakshadweep, they abandoned the site inventory. Now, my lord, this is what your lordship will find is now, my lord, the claim. Now, page 40, page number, this should be 45, 40, 47.
This is 47.
Well, at page 47, your lordship will find Raura MW PV site visit. Overview at page 48. This site visit was undertaken by BHEL, IOCL and OPS teams to review the issues firsthand and to discuss or recommend improvements. This is especially aimed at increasing system uptime and also improving total generation of output. Malad, what does it mean? That Malad, the system is not performing. Then Malad, PCU operational issues. Now Malad, kindly see page 49. The Raura site has a total of 20 OPS PCUs, each of 250 kilowatt capacity, installed and operated in two separate, it should be room areas. Most regular issues are in the 3 MW room, where 3 or 4 PCUs have exhibited the most problems. These problems have been documented previously, and especially PCU 9, 10, 18, 20 demonstrate the most problems. After the first few months of operation, and control room was considered too warm, and evaporative cooler or desert cooler type units were requested by BHEL to provided by OPS. A top-mounted air extraction duct system was installed along with PCUs. External air delivery system is shown below. After the first few months of operation, the control room was considered too warm, and evaporative cooler, desert cooler units were requested. Then next page. Kindly see, my lord, again admission of poor performance. PCU Part 1 PCU specifications. The performance of PCUs depends on them being operated within design specification. Design specified room temperature should not be routinely exceeded. There should be appropriate cooling air, and control room must be very clean. The cabinet filters and fans direct air over warmest internal areas to manage component temperature rise. Operation with the doors open is not recommended, as it allows substantial amounts of airborne particles and materials to enter the cabinet. At Raura site, the site is very dusty and electronics are susceptible to dust buildup and electrical tracking arcs along the pathways. The current operating condition can be expected to lead to random failures, especially with dust and moisture extremes. The desert coolers also add a lot of moisture to the air in the control room, and this can cause condensation with dust and PCU particles. Now, they give a diagram to show us to how this can happen. Of course, none of this is ultimately proved. None of this is adverted to. Then please see the next narrative, dust and moisture. The Raura control room is inherently hot due to the high ambient temperatures as well as being very dusty site. Operation of the PCUs with the doors open permits a high level of dust to enter to cabinets. Furthermore, the evaporative coolers inject a lot of moisture into the room and cabinets. This can lead to condensation, and dust becomes encrusted across electrical connections and joints. Under these conditions, the PCU's control cannot be expected to fail safe on every occasion. Then, next page, it should be, I don't know, 58 or something. Summary of PCU operational issues. The reliable operation of PCUs and have fail-safe operation depends on them being operated to design specification. But ultimately, the admission is they did not perform for whatever reason. A multitude of reasons have been given. Then, please see control room issues. That's page 57. Control room issues. Please see the second paragraph. Currently, the control rooms have the problem that unfiltered air is injected into both the rooms, along with high levels of dust. The rooms use evaporative coolers that also inject a high level of moisture into the rooms. The challenge at RARA is to find the most reliable, cost-effective manner to manage room temperature to below 50 degrees centigrade for most of the year, to keep the room clean by ensuring that high levels of dust are not able to enter, avoid humidity in the room. This problem is accentuated somewhat by the orientation of the room, which has the highest heat source on the side with the highest solar gain, southwesterly direction. Then, well, at page 60, again, well, they say the same thing. Control room. An improvement in the thermal operation of the control room is possible. Clean outside air is required to be carefully channeled into the room and directed into the hottest areas of the PCUs, then extracted. It is observed that currently the majority of incoming air comes through random points, such as when doors are open, the cable entry gaps in extractor fan openings, the side roller door access when it is open. The above dictates that airflow into the room is variable and also prone to permit large amounts of dust, major problem when dust storms occur. In short, there needs to be a major ventilation entry point with filters and loops so that the adequate amount of clean air is continually available for the PCS inflow. And the similar thing, I don't want to trouble you, Lordships, control room summary, everything, there's a problem in everything and there's a suggested solution, but the fact is, the things have not worked. And all the payments that are withheld are on account of retention. Now, I would appreciate that in such circumstances, there would be in the statement of claim an attempt to show what is the contract, what is the performance expected under the contract, what are the exceptions to the contract, when are the payments to be released, when can the payments be retained, when can the payments not be retained. Your Lordship has found no reference to the contract here at all, and we have now reached the annexures to the statement of claim, which starts from paragraph F. Now, here, from annexure F, at page 68, your Lordship will find that they proceeded to modify the statement of claim, amend or modify the statement of claim. Now, what is the amendment? Let us see. The claim subject is the claim and interest as in the statement of facts as per section 23 of the Act of 1996 and as per Rule 12 of WMSC FESC rules such and such. Kindly note that further to our communication of statement of facts dated 10 July 2016, our total principal claim for the different projects is depicted in the table below. So, they merely compute it and make the claim 67,15,416. There is nothing else that is changed. That's it. And there are annexures, you'll also find annexures are only tabulation of how their claims have been arrived. And your Lordship has seen that these are all claims which are on account of retention monies. Just for example, if your Lordship see, at page 71, the last two paragraphs or last two rows, you'll Lordship find at the end 10% retention of PCU cost, 10% retention of INC. This is all that there is in the statement of facts. So, what do we have? We have a statement of what are the works that they performed. Your statement of why their performance was not satisfactory. And we have a statement that all the monies that are withheld are on account of retention. There's nothing more. And here, now, I am asking myself this question. Ultimately, to adjudicate as to whether they're entitled to these amounts, one would have to see whether their performance was dependent on the performance of prior reciprocal obligations by BHEL. Whether BHEL failed to perform its reciprocal obligations which correspondingly affected their performance. Whether therefore their failure to perform can be excused and they're still entitled to be released the retention amounts that have been withheld. But there is absolutely nothing to show that this adjudication was ever even attempted. Now, your Lordship will now see, we filed a written objection, only a preliminary written objection at the relevant point of time because we said that, This, my lord, cannot proceed to adjudication. That your lordship will find at page 80. Oh, দেখো কাল পরে দেখো। Well, the written objection your lordship will find is at page 80. Well, I'll take your lordship to, my lord, only a few paragraphs because this was a preliminary objection. Well, please straight away come to paragraph 5 at page 82. Well, at paragraph 5, towards the middle of the paragraph, it starts with the claimant company participated. The claimant company participated in such tender invitation and the respondent awarded various work or purchase orders to the claimant for supply of materials, installation and commissioning and operation and maintenance work. Along with the said purchase orders and its enclosures, the claimant company signed and agreed on various other documents, including technical specifications, payment terms and conditions, and general terms and conditions, which together constitute the binding contract between the parties. The said purchase orders issued by the respondent are annexed as Annexure A. Well, I'll not trouble your lordship with those annexures right now. Then 6. Claimant performed the contract only in respect of the supply of materials and installation and commissioning, and thereby received full payment for the same from time to time as per the terms of the contract. However, the claimant failed and neglected to provide the operation and maintenance services and to fulfill the warranty specifications as stipulated in the contract, and willfully abandoned the site, resulting in great hardship for the respondent to comply with its own contractual obligation with its clients and exposing the respondent to the risk of financial loss and suffering. Well, BHL had undertaken these contracts and had subcontracted these works to OPS. The failure of the claimant in performing its duties also resulted in huge penalty from end customer on the respondent. Several correspondence from the respondent to the claimant from time to time, highlighting therein the particulars of work the claimant had failed to perform and requesting the claimant to take immediate remedial measures, failed to evoke any positive response for the claimant. Instead of taking immediate remedial measures to correct the fault in the material supplied and commissioned by them, claimant chose to reply to the respondent with unfounded and flimsy explanation for failing to meet its own contractual obligations with respect to the operations and maintenance of its materials and its warranty specifications, blaming the design and even attempted to partly blame the respondent. Ultimately, the contracts were terminated as abandoned, and the respondent was forced to engage third-party contract to perform the operation and maintenance services at the risk and cost of the claimant. Then, well, at paragraph 7, the respondent...
Mr. Shah, were these all independent contracts given to the claimant, or there was a tender process, the claimant participated for performing various kinds of work or various
some
works?
Independent contracts, some following a tender. And that is there in the statement of facts itself. But they have ultimately sought to combine all their grievances and the payment was under all these contracts under a single statement. But what is very important is that they themselves admit that they could not perform the work, they had abandoned the work, and the work was not up to the quality. Of course, they give justification for that. But today, if that is the basis of the claim, then one would have to ultimately sift through the justification, adjudicate the justification, and see whether ultimately these justifications will hold good under the terms of the contract, therefore entitling the claimant to the payments. But that attempt was never made. And we have highlighted here very clearly that these were the faults. Whatever supply items you've made, you've been paid in full. Whatever performance was there, and because the performance was not achieved, because the warranty expectations were not met, there were amounts that were withheld. And finally, we have also suffered loss and damage because we abandoned the site and left. And that is what we have said in our counter statement. Your lordship will find that this is the general refrain. I will just place 2 or 3. It's a very short counter statement because this is the issue that is raised. Please come to page 84, about 6 lines from the top of the page. The respondent, after due testing and acceptance of such installation and commissioning, paid invoices for the same in full as per the terms of the contract. Thereafter, the claimant was under an obligation to furnish a performance bank guarantee for the amount as specified in the contract for fulfilling warranty expectations, warranty specifications. So, my lord, payments made, you're supposed to give a bank guarantee for, my lord, performance obligations. However, the claimant failed and or neglected to furnish such performance bank guarantee, and even failed and or neglected to perform operations and maintenance services and to fulfill warranty specifications despite requests from the respondent from time to time. The respondent never issued acceptance certificate in favor of the claimant with respect to the operations and maintenance services and the warranty specifications. As per the terms of the contract, the occasion to make payment in respect of operations and maintenance services would arise subject to the claimant furnishing performance bank guarantee and performing the operations and maintenance services or fulfilling warranty specifications, and the respondent subsequently certifying satisfactory performance in respect thereto. Hence, the said amount in respect of operations and maintenance services never became due, and the question of making payment in respect of operation and maintenance services could not and does not arise. Neither the performance bank guarantee, etc., were furnished. And then, my lord, we say how, my lord, we were forced to engage a third-party contractor, and, my lord, losses were suffered. And then at the bottom of paragraph 7 at page 85, you'll also find that, my lord, the respondent reserved its right to file a detailed statement of defense and counterclaim. At paragraph 9, my lord, there's an indication that there's a counterclaim of more than 6 crores. That is, my lord, the long and short of, my lord, counterclaim initially.
Did you actually file a counterclaim?
Yes, my lord, this is, no, before I could file a counterclaim, my lord, the reference was, my lord, concluded and an award was passed. I shall show your lordship how, my lord, summary this entire process was. My lord, what I have tried to show your lordship at this moment is, let us forget the counter statement also. My lord, from the statement of claim or the statement of fact that is filed, there's admission of failure to perform, there's admission of abandonment of site. And, my lord, the claims are on account of retention money which they seek release. And, my lord, we have only pointed out that this under the contract was subject to your furnishing performance guarantee, meeting warranty expectations, and, my lord, ultimately work being certified, which was never done. Now, my lord, I am, my lord, at this stage, my lord, wondering as to how the tribunal would then, my lord, proceed to frame issues in the matter. My lord, even if, my lord, formal issues are not framed, the issue that would naturally fall for consideration is, my lord, did you perform the work to the satisfaction required under the contract? Were you therefore entitled to payment under and in terms of the contract? Did you abandon the site? Were you justified in abandoning the site? What is the consequence of your abandoning the site? Nothing. Nothing at all. Now, my lord, if your lordship will now see, my lord, here, my lord, the purchase orders have all been annexed, my lord, which really are the contracts from page 90 onwards. My lord, these are the purchase orders, and your lordship will find the general terms and conditions of the contract we have also reproduced at 120. I don't want to take your lordship through that, because ultimately the tribunal never, my lord, reflected on it at all. Well, I can, my lord, say that the tribunal was wrong in interpreting it, or the interpretation of the contract is perverse. But, my lord, there was no attempt to look at the contract.
After this, I think we should see the award immediately.
Yes.
But not today.
Oh.
এই আবার যেটা বলেছি এটা উপরের দিকে যেন থাকে। Mr. Shaha, comma learned senior counsel representing the appellant. This is a 37.
37.
Oh, you lost before the learned single judge.
Lost comprehensively, but I'll show you lordship how.
Represent the appellant begins his opening submission but does not conclude. Paragraph. কবে হবে? শুক্র সোমবার থাকুক। Monday, let it be in the list. Let's list this matter once again on Monday, date thou, comma, retaining its position. You take back your book. এই 25-এর বই আনাবে।
think they're going to.
কেমন আছে?